Court officer, am I audible? Madam, am I audible, madam? Court officer, am I audible? Court officer, am I audible?
Yes, what about this?
Court officer, am I audible?
Madam, list 2 will be called out. Court officer. Yes. Madam, list 2 will be called out.
Mediation will matter common and first invite and receiver.
Madam, I'm audible, madam.
Sir, yes.
Oh, thank you.
It will be called out, madam. Okay.
ಫೈಲ್ ತಂದಿದ್ದು 13 ಅಲ್ವಾ ಅದು? ಓಕೆ. Mediation drive matters. 2 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ, ಇವಾಗ ಎಲ್ಲ ಆಗುತ್ತೆ.
My lords, with your permission.
Out of the list.
My lords, WP 19102, I'm for the husband respondent. This was disposed of on 24/7/2024. I was given a direction to sell the jointly owned matrimonial property within a period of 1 year, my lords. I've moved an application for modification of the judgment only with respect to the time period, since the 1 year has lapsed.
Who passed that order?
This court, my lords. If it may be listed, please.
Wednesday.
Lordship kindly.
Grateful.
Lordship kindly. One matter for 230. The urgency is this, my lord. My lord, the court have passed a custody of a child. My lord, tomorrow the 3 years old child. And my lord, the morning to evening they are given accommodated time to them. No, it's very difficult to manage the kind because
Why?
because 3 years child, mother has to take care of it because food, everything. But the 3 years he has not connected to the child. Suddenly filed an application memo got
Order was passed.
day for yesterday, my lord. We received yesterday order copy and we filed in the morning.
If the order, if the office objections are complied with,
Please, my lord.
matter will by 1 o'clock.
Much.
Yes.
1 PM if complied.
A suit was filed, my lord, seeking the judgment and declare null and void because wife is a Christian, husband is a Hindu. Marriage was solemnized under Hindu Act. But the stay of the judgment and decree was sought for. That has the expiry order has been rejected. Therefore, it has not been granted Monday.
When was it passed?
Dated for yesterday. I got the certified copy yesterday.
Or if office objections are complied with, list the matter on Thursday.
Well, it's Monday, well, there is urgency, well, because
There are so many matters on Monday and Tuesday. I can't. What is urgency for this? Tell the court.
well, there are certain
Order passed by the court dismissing your application cannot be a ground for
not
the
urgency.
urgency.
Expiry
So
order
if
has
it is
been
not
granted.
taken up on Monday, what will
Study
happen?
is with the mother, my lord, but in terms of the decree, my lord, which is null and void, which is a nullity, my lord, the husband now, my lord, looks for execution of it. If execution is
Correct. 2-3 days, it doesn't matter. Take it up on. We'll take on Thursday.
Your
Yes.
Ladyship, this is an RPFC matter.
That's
It was disposed of directing me, the CMS proceedings were disposed of directing me to pay maintenance of rupees 1 lakh per month, despite my medical records and my financial records being before the court marked as exhibits, showing my incapacity. The execution petition filed by the respondent is listed on 31st of this month. If I may request for the
When
matter.
was the order passed?
The order was of the year October 2023, Your
What are
Honor.
you doing from Karnataka?
Subsequently, Your Ladyship had passed an order directing the respondent not to precipitate the execution proceedings. However, post that, the order had not been extended due to inadvertence.
Still, then also it can't come up. If you file it, if it's a fresh matter, office objections are complied with.
It has
will be
been heard by Your Ladyship.
It will come. It will come. There are so many matters now, and it's not because all the matters are coming to the list. All the matters are heard.
Completely.
No out of the list now, unless and until you show the great urgency.
On 31st of this July or 31st of this month, they will file for
That is
NBW
31st
to
of
be
July
issued
is
against
Thursday.
Thursday. If I may request for any date before that, Your Ladyship.
Thursday. Yes.
Grateful.
My lords, and for the husband, we are challenging the interim order wherein an additional 20,000 maintenance has been directed towards the husband to pay to the respondent. He has already been paying 50,000 by the DV code as maintenance. So we are just challenging that as the amount is quite exorbitant and more than 50% of his
Why,
income.
what is that? What is urgency now?
The urgency is just to just challenge the 20,000, my lords.
So why you have to mention? If you file, it will come.
Yes, my lords.
File.
We have cleared all office
don't have to take the
objections.
memo. You file it, standard instructions to the registrar. The moment your matter is numbered, it will come in the list. Don't mention any of those matters. And if whenever you're mentioning, there should be an urgency, not that you have filed a matter. Now, all the matters that are filed are coming to the list every day. And I don't expect any of the advocates to make a mention.
My lords,
Unless and until you make out a urgency. Yes.
My lordship, yesterday, my lordship had agreed to get the matter listed today, the writ petition matter. For some reason, it hasn't got listed today. Maybe listed on Tuesday, my lordship. There's an urgency.
Yes, take it up. If something is not listed, in spite of giving a memo, ask them to tell the court. They can't take it so casually.
Much obliged.
Yes.
Earlier, I had moved a memo for a posting, my lords. it's not been posted.
What is that? Now, what the advocates are doing is, you give a memo, the court will say unless objections are complied with,
Petition duly
it
complied
shall
with.
not be listed. You will not go there to
Objections are
comply
duly
with the
complied, my
objections.
lordship. And in
They will
meantime,
come and tell the court that it is the case. Again, you come before the court and tell that it is not listed. How it will be listed?
my lordship, in the meantime, petitioner has been
You come
arrested.
at 1:30, take that memo and ask the court, ask the registry why it is not listed. Come at 1:30.
Petitioner has been detained, my lordship.
We'll see, come at 1:30. Whoever makes a mention that in spite of giving a memo, it is not listed, ask them to come at 1:30. In the meantime, find out and tell them. Yes, yes. Yes.
My lords, one submission in list 2, serial number 95.
It's not, now it's only out of the list. Once the list will be called.
Your Worship, apologize. In another matter, there was an NBW already issued by a court in Mysore for an interim order that was passed under section 125 clause 1. Matter is listed today in Mysore.
When is that order passed?
The order was passed on 7th of February 2025, Your Honor. I have filed this on 7th of July. The writ petition has been filed, Your Honor.
Every matter of yours cannot be adjourned.
Any date convenient to the court, it is
Come
listed
to-
today.
If you file it, it will come. If you file it, if you have already filed.
It is already filed.
When did you
7th
file?
of July it was filed, Your Honor.
When it was listed?
It has not been listed before.
It is not listed because office objections are not complied with.
Your Honor, I had stated
The
that
office objections are not complied, no matter will be listed from now onwards.
if any, I will comply if it may be.
If you comply,
any
it will come. For that, don't have to give a memo. I already gave the instructions to the registry. Every matter that is complied with, next day it should appear in the list. That has a standard instruction. So don't have to take the memo.
With lawsuits kindly. Second list, Mila. Second list.
Second list for mediation. right?
Mediation,
Yes.
yes.
In that serial number.
Let them complete out of the list, then you.
Second list, one matter for withdrawal.
Serial number
Parveen,
No, this is the second list.
I've re-
28 for withdrawal.
Serial number?
28.
it's disposed of. It's become infructuous, matter has got decided, court.
Submitted to the main petition itself is decided. The dispute between the parties is already settled. Hence, the petitioner wants to withdraw the petition. Memo is taken on record and dismissed.
Obliged to.
Yes.
Serial number 76, Mila, in the second list.
70?
76, Mila. There the petitioner has obtained an ex parte order of stay where no maintenance are being paid, and it was listed on 5/6, and your lordship directed it to be listed on 11/6, but never listed. Now all of a sudden it has been listed for referring to the mediation. Not non-payment of the maintenance, my lord. Wife is fine.
It is submitted that there is no scope for mediation. Delete this matter and list the matter on 11th of August.
Any day, earlier, because next week, because
This is a matter on 1st of August. Already so many matters are already
true,
given
Mila,
date.
because should have been listed on 11/6. In spite of my moving there, they were not.
First of- because court cannot.
I do understand that, but our difficulty is also for last 6 months. No,
More than your difficulty, court difficulties you have
no,
to see.
for last 6 months, no amount is paid. That's why
We'll see.
wife
we'll
is
see.
without any
See
employment.
that the matter is listed and heard on that day.
Yeah.
Yes.
Date.
August.
Okay.
69 in second list, my lord.
Hmm.
Chance of
Huh?
69.
chance
No
of
chance of mediation.
mediation.
This matter also delete.
Serial number 36, my lord.
Date, my lord.
Serial number 36.
In all these matters, date will not be given. They will come eventually. Yes.
Serial number 82, my lord.
Serial number 36.
Serial number
my
80,
lord.
serial number 82. There's one more connected matter, my lords. RPFC 196 of 25. Both together shall go for.
Take that number. We will list this matter for mediation along with so and so.
Serial number 36, my lord. Serial number 36.
Yes.
In spite of the restitution conjugal right, she refused to join there is no chance of mediation.
So 36 also delete.
Serial number 81, my lord. Interim order is there. Serial number 81, second list.
No, let it go. Then it will continue. If it is there, it will continue. Don't have to. Yes.
69,
List
date, madam. Date, madam. 69.
List the matter on November 24th.
My lords,
November 24th. It will come. I'm taking up all the matters. They will come. Yes.
my lords, serial number 95, my lords, in list 2.
Hmm.
There's no chance for mediation, my lords. Lok Adalat also, it was referred on the
Yes,
last.
yes. Delete. Next.
Date may be given, my lord.
No date will be given. Yes.
All matters are state before the mediation.
Yes.
48.
My lord, serial number 98, 99.
Hmm.
There is no chance of mediation.
80,
98, 99, my lord.
98, 99.
So
Date
nobody
may-
wants to try mediation.
There is no chance.
Oh, because earlier was mediation done?
Yes, my lord.
Yes, 98, 99, delete.
My lords, 89
Date
as
may
well.
be,
Mediation
date may
field.
It will
be,
be given.
my lord, second round litigation, my lord.
It will come, Mr. Counsel, it is 25 matter. For 25 matter, no urgency for the
48
date.
before mediation.
Yes,
My lord,
89 as well, my lords. Mediation field. It may be posted in a regular course.
what is that?
Serial number 89 was referred to Lok Adalat, the mediation field. It may be posted in regular course.
Yes, 89 also delete.
Grateful.
my lord, serial number 30, list 2. It may be listed for mediation in Mysore arbitration.
Mysore.
Which one?
Yes, 30,
30
Mysore,
and 100, Madam Mangalore.
100, Bangalore. Anyhow, whatever is not mentioned, it will be before Bangalore only.
No, Mangalore.
Mangalore, yes, 100, Mangalore.
100.
Yes,
Serial number 16. It has
16.
become 16 in the
In
first
which-
list. First list.
Ah.
It has become infructuous.
take that.
The parties have settled the matter before the Lok Adalat.
It is, a memo is filed stating that the parties have settled the matter before the Lok Adalat on 14/12/2024. Hence, nothing suffices for consideration this petition. Memo is taken on record and dismissed as infraction.
Great.
Yes.
Serial number 25, can you try, my lord?
Huh?
Serial number 25, my lord.
There are two
Media.
lists.
First list, my lord.
Hmm.
List number 1.
Hmm.
Lok Adalat, my lord.
What Lok Adalat?
My lord, mediation.
I remember this matter. I remember this matter. The respondent is contesting this matter tooth and nail. And you say
No.
mediation.
No, no, he has also told me last time. That is why I'm telling you.
When
Otherwise,
he comes,
yes,
both
my
of
lord.
you
I
both
know.
will think about it. Yes,
Because
next.
this
My
matter,
lord, serial number 61 in list 2, my lords.
Yes.
It may be referred to Bangalore Mediation Center.
Yeah,
Okay, all matters will be referred to Bangalore mediation. Otherwise, you want, you should tell. Yes.
My lord, 26 and 47,
Of which list?
second list, my lord.
Hmm.
We have tried mediation, my lord. It has failed earlier.
26 and
47.
22 not 26, sir.
Second list, 26 and 47.
26 and
47, delete. Yes, next.
Serial number 1, list number 1, serial number 85, my lord. Pray for weeks time. my lord.
List number 1, there are no 85 matters in list number 1.
mediation matters.
My lordship.
List 2.
List 2.
List number 1, serial number 35, my lordship.
Yes.
We have my senior colleague is unwell. Yesterday he suddenly became unwell here. That's why yesterday I was representing the case. So he is unwell, my lordship. You have informed the other opposite side also.
Because I appear for the respondent in this matter, this reputation is not maintainable at all in the first place. It's infructuous, my lord.
We can't
If the
I'll take up on Monday, then you can tell them. Monday.
Sorry.
It is submitted that the
Which
counsel for
one?
the petition is unwell. This is the matter on Monday. Monday or any other date?
Oh, Monday is good. All right.
Monday is okay. Yes.
My lords, list number 1, my lords, serial number 24, my lords.
20?
24. I
Ah.
appear for petition, my lords. The on record counsel is not well, my lords.
Counsel is unwell.
Please, my lords. Any date, my lords?
No, it is a 25 matter. We'll just see.
My lords. Monday, my lords. Under
This is the
same-
matter on, because there are so many matters on Monday, Tuesday and Wednesday. Yesterday, entire list is dates are given. List the matter on 4th of August. Yes.
My lords, list 1, serial number 26. I'm proxy counsel. Advocate and record is not well. So seeking adjournment. I've informed the.
Have you informed the other side? 20.
Respondent, my lord. Serial number
26, counsel, the petition is unwell, same order. This is the matter on 4th of August.
2.
Yes. Call the list.
My lordship, serial number 13, list number 1. I seek an adjournment because they have submitted almost 700 pages. I need to counter that.
Yes, list
Serial
number?
number 13. It's in the first list.
Have you informed the other side?
Yes, he's right here.
I have to seek instruction from.
When do you
Because
want?
they need to file objections too for the affidavit.
When do you want?
26th of August, my lordship.
At the request of party in person. List this matter on 26th of August.
Much obliged, my lord.
Yes.
List number 1. For being spoken to, serial number 1, Abu Bakr Shafiq.
I appear for the petitioner, my lord. In this case, I presented a memo for being spoken to, my lord, wherein the originals memo with the original medical bills on 3/4/2025, my lord. Entire compilation may be directed the registry to.
The matter is listed for being on the caption for being spoken to. It's a memo is filed stating that the petitioner has filed the original medical bills by way of a memo on 3/4/2025, and there may be the same may be.
The entire compilation may be returned because it contains.
To return the entire compilation dated 3/4/2025 to the petitioner. Because the petition is order and the registry is directed to return the documents along with memo dated so and so. Next.
For dismissal, serial
My
number
lord,
2.
one more submission, my lord. I have some medical emergency of my wife. I had to proceed to hospital, my lord. My colleague will be there. Another 2 matters in list 2 is there, my lord. My colleagues will represent and
Two matters are for mediation.
Obliged.
Yes.
Serial number 2.
All those matters are referred to mediation on 4th. Yes, 2.
So I appear for petitioner needful done, my lord.
It is submitted that the needful is done. List this matter after service of notice. Delete from the caption dismissal.
Serial number 3.
Appearing for respondent in this.
Lord, in serial number 3, name of KV Narasimhan may be shown in petitioners. SB Totat has filed his memo of retirement. My name is wrongly shown in respondent.
Thereafter,
Memo for dismissal.
next. What should
Next
happen?
submissions, next date of hearing.
What is this memo of dismissal of writ petition filed by advocate for petitioner, not respondent? A memo is filed to dismiss the petition
By the respondent.
I am for the petitioner.
for petitioner. Oh, look at it. That's what it says. Show it to him.
I will see my.
It's yours, not that.
So I will
Leave
see.
the
Bharat. No, it is not. It is a memo for. Non-payment of interim maintenance. So that is. My lord, they have not paid us. I'm sorry, my lord. They have not paid any maintenance amount. That
For
is
his
the.
petition, you will file a memo and get it dismissed.
They have not paid. They
Give
have
that,
not paid any amount of
the
interim
order
maintenance.
sheet. When is the interim order passed? There is no interim order.
No interim order.
And then what is
So,
this
so far, they
memo?
have not paid any.
That is not the problem. That's your problem to file.
Memo may not be right, my lord. Sorry.
So and so in the place of so and so. It is submitted that so and so has filed the NOC Wakalat, print his name, list the matter on 5th of August.
Lord, name of K. Nitish, my lord, in
Write
respondent may
it
be
and
deleted.
give it to the court officer.
Name may be deleted in respondent.
Whose name?
KM Nitish.
Delete the name of Mr. KM Nitish. Yes.
Great.
Serial number 4.
In this case,
Yeah.
before the trial court, MC is
Disposed of.
dismissed on the ground of dismiss for non-prosecution. Against that order, my lords, miscellaneous petition is pending. That, my lords.
That will take its own time.
No, my lords, the now problem is the vacant court, my lords.
First, then why are you not complying the office objections from 2023? That's how it is listed before the court.
I need some documents, my lords, the main petition and also the
Of each
assets and
time is
liability.
granted the default order.
Much.
Delete the caption for dismissal.
Serial number 4. 5. Giriraj Rohit Sikvira.
For the
Serial
petitioner, my
number
lord.
5.
What is the report of the family court? 17/7/25. Where is the order?
Matter may be disposed within 3 months, my lords.
No, on the last occasion when this matter came up, it is informed to the court that IA for maintenance is not decided.
Yes, my lord.
It is a misrepresentation before the court. This court has called for a report. Now the report says orders are already, this court has passed orders on IA number 1 filed by the petitioner and rejected the said IA by the order dated 24/12/2024. Why such a representation is made before the court?
Proxy counsel, my lord.
This writ petition is filed.
Direction may be given, my lord.
Huh?
Direction may be given, my lord.
No direction. I will impose exemplary costs on the petitioner for making these kind of misrepresentation before the court and wasting the court's time, wasting the judge's time, fifth additional judge, for sending this report.
Sorry, my lord.
No, sorry. This matter has come up on 16/7/2025. On that day, it is submitted before this court that the criminal miscellaneous is filed seeking maintenance. In that, an IA is filed seeking interim maintenance, and the same is not disposed of. Then this court has called for a report from the fifth additional principal judge, family court, to place a report before this court. Why IA number 1 that is filed in the year 2022 seeking interim maintenance is not disposed of from the last 3 years. A report is placed before the court wherein it is stated that IA number 1 filed by the petitioners under section 125 CRPC was rejected by order dated 24/12/2024, and now the case is posted to 1/8/2025. And the parties to the petition have taken several adjournments for filing SSR liabilities in compliance with the directions issued by the apex court. When the matter was in the stage of cross-examination of PW1, he pressed the IA number 1 and the IA number 1 was disposed of on 24/12/2024. A perusal of the report shows that already IA is disposed of, and the petitioner, without verifying, the petitioner has stated before the court that IA is pending, and this court has called for a report. This petitioner cannot waste the time of this court as well as the time of the trial court. The criminal miscellaneous of 2022 cannot be, this court cannot pass a direction to dispose of the matter. Accordingly, the petition is dismissed with cost of ₹1,000 to be paid to the Advocates Association.
Cell number 6, Viresh K.
Yes,
I have filed a memo for withdrawal.
take that. It is the main petition is a memo is filed, but the main petition itself is disposed of by the family court. Yes, memo is taken on record. Next.
Cell number 7,
For the petition in this matter.
Yes.
Jairamaya.
Appear for the respondent.
Yes.
The respondent filed a divorce petition before the family court.
Respondent is?
Filed divorce petition before family court, and petition also filed a counterclaim along with the divorce petition.
Both want divorce.
Divorce. And it's a good matter for settlement, my lord, as per this one. But the thing is
the
that they are seeking 1 crore. 1 crore, it's impossible.
We'll refer it to the mediation.
My lord, sir, it was already spoke between the parties. Even the parties also present before
They
the court.
are also in criminal case also they have filed. That also sent it to
What is the
mediation.
financial status of the husband that she is seeking 1 crore?
And she was also working. For that only.
Working, my lord.
No, he's working.
Please, my
How
lord.
can anybody pay 1 crore?
No, 1 crore is not sought, my lords.
Yes, my lord. Kindly peruse this petition.
My lords may kindly come
so
to
that
the.
you can respond. Yes.
Please, my lords. I may be permitted to impugn the order which is challenged before this honorable court. Please.
Forget about the order. What is this 1 crore? Both of you want divorce.
Please,
Why
my
don't you
lords.
take
There's a
divorce?
child who is involved and he's taken an admission in a very good school.
Correct. What is your requirement?
And they have given for the marriage purpose, the respondent have given numerous of gold ornaments and everything
What
is.
is ornaments?
It is under his custody, my lords. Under the custody of the petitioner.
So asking return
Ornaments
of,
was asked, my lord.
return of those jewels is another aspect.
Please, my lord.
Asking 1 crore alimony is not a small amount.
No, if my lords kindly come to the petition for a moment.
Where is that petition?
That is at 130, page number, annexure. What?
When both of you want the same thing, happily talk,
Yes.
mediate, settle, and you can go ahead with your life.
I have.
And
I have
don't
no
have to
obligation.
go
If the
around
party is
the
able
courts
to.
for years together.
Actually, can I speak, ma'am?
Yes.
Actually, mediation is already done, ma'am.
Huh?
Mediation in the session court, it is already done. And there.
What is your requirement? What is that you want?
I have a 6-year-old baby, ma'am. So I'm not working. And they are telling I'm working, but actually from 2 years I'm not working.
What is your qualification?
I am from, ma'am. Actually, due to marriage only, there is a gap between 4 years, ma'am. I didn't work after my studies. I didn't work, ma'am. So due to that, I didn't get any kind of job. So that is the main reason.
No, that's what. What are your terms of settlement? You should be. First of all, you should know what is that you want.
Actually, my husband and my in-laws are well settled, ma'am, and they are having two the sites and the house also, ma'am. So that's why I'm demanding that. That's it. And also my kid she is 6 years now, and from past 3 years they are not taking care of. Everything will be under my own. She didn't even. That's the reason.
I'll keep them before this honorable court.
What are the terms according to what is that your client?
My lord actually is getting salary of 70,000 rupees. When they are together, they are obtain many loans, paying monthly EMI itself more than 51,000. I think 36 lakhs loan is there. He's paying it. And only one dwelling house is there. He's residing along with the parents. The parent is astrologer. He's taking care of livelihood for astrology. So he's not getting any much income. And only one dwelling house. She's telling 2 houses or something. No, 2 houses.
Then who will take care of the daughter?
Daughter, I am ready to take care. I am ready to, in the objections, objection statement itself, petition stated.
How much you are paying now and how you are taking care now?
There, earlier, whatever this one fees and all that admission charges I paid. Subsequently, she left. When we came to know that her adulterous life, immediately she filed a complaint before the Kanpura police station. Subsequently, filed divorce petition. Subsequently,
the MC filed which year?
MC has
been filed in 2023, my lord.
23, my lord.
When she left the matrimonial home?
She left on after 3 months, my lord. So that's
30th/7.
July.
No, July left the matrimonial 18/6/2022. She left the matrimonial.
18th April 2018, the marriage was, and on 18th April 2018, the marriage was happened, my lords. Subsequently, after 3 to 4 months, in the month of July, she left the matrimonial home. And the case in 2019 April, at the time of leaving a matrimonial home, she was already carrying, my lords. She was in 2019.
So it lasted only, married life lasted only for 2-3 months.
Please, my lords. And subsequently, daughter was born on 30th
From
April.
2019 till 2025, they are fighting.
My lords.
They could have settled it.
And subsequently, the respondent had, with the involvement of the well-wishers, they had again went back with the petitioner, my lords. Again, they got separated in the month of June 2022. From
List
June,
is smarter on Tuesday, 5 o'clock in the chambers. Both the parties shall be present.
Tuesday, 5 o'clock.
9/7. Cell number 8.
my lords, make one submission, my lords, on Wednesday, my lords.
Wednesday.
Obliged.
And interim order may be extended, my lord.
Interim order earlier granted is extended till then.
Cell number 8. For orders matter, cell number 8. Nagaraj Reddy D.
10 days time, Lord, so it is told that the matter is settled before the executing court.
Week's
I get
time.
Please.
Yes. And in the meantime, you have to comply with the office objections.
Lord, I withdraw the petition, Lord, if at all the order sheet has come from the
A
trial
week's
court.
time.
Please.
Cell number 9.
This case I am for the petitioner. The
seeks
counsel who is
Yes.
the counsel who is appearing for the respondent before the trial court has not accepted to receive the notice. Therefore,
When the matter was listed before the court,
no PF has been paid, Your Lordship.
issue notice.
Cell number 10.
That the needful is done. Notice to the respondents. List after service.
Cell
Yes.
number-
Much obliged.
Abide service of notice. This is
Cell number-
matter after service of notice.
Cell number 11.
Hearing for the petitioners.
Have it.
You
Lordship,
served the hand summons?
we have served and filed the memo, Lordship.
As per the order passed by this court, when counsel for the petitioner submits that they've served the hand summons on the counsel appearing for the respondent. What is the name?
Adi Narayan, Lordship.
What is the initial?
AM, Lordship. Adi Narayana M.
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 Adinarayana M. On?
19/7, Lordship.
On 19/7/2025.
Lordship.
Liz, hence the notice to respondent is insufficient. Print the name of the counsel. Liz's matter on 31st.
Lordship, an interim order, Lordship.
31st will finally dispose it.
Please, Lordship.
Cell number 12.
Petitioner, your lordships.
Serve the hand summons.
Yes, and I've mentioned the advocate's
What is the name?
Madhu Yadav.
It is submit, say, Madhu
Let me
Yadav
post it
on
for-
so and so. On which date?
Madhu Yadav.
I had served in summons, I don't know which date, but I hadn't mentioned the
Must
name.
have signed it, the
So
date
I was
must have been
directed
there.
to file a
Serve the
memo with
counsel
his
so
name.
and so. List the matter, print the name of the advocate. List the matter on 5th of August.
Much obliged.
Yes, ma'am.
Cell number 12. 12 adjourned. Cell number 13.
Not 12 adjourned, what you called is 12.
Cell number 13 adjourned. 14.
For respondent. I'm for the petitioner.
Yes.
I'm challenging the order passed in GNWC 175 of 2017, wherein the learned judge directed the petitioner father to pay the entire school fees in its entirety.
Come to the impugned order.
Impugned order is at page number 18, your lordships.
80.
In page number 18. While filing the one more issue that I would
Not 80,
18, your lordships.
18.
18.
Petitioner husband is hereby directed to pay the educational expenses of the minor child. Day one of the educational career of the son. Subject to producing the receipt of bills of the school to the satisfaction of the petitioner. Apart from also directed to pay the maintenance expenses of 20. What are the school expenses?
School expenses comes up to 12 lakhs.
Per annum.
Overall. While at the time of filing the application, it
What is
was
it per annum? How much it is?
per annum. Now it has gone up to 2.5 lakhs, 2 lakhs, around between 2 to 2.5 lakhs.
2.5 lakhs.
Yes.
Now if the arrears have to be paid, they are 12 lakhs.
12 lakhs is what they've claimed.
And what is the income of the husband?
Husband, I have filed my ITR, which is about 6 lakhs, your lordships. And wife earns about, as of 2022,
6 lakhs per annum.
Per annum.
Per month.
Per annum. And wife earns about 82 lakhs per annum. As on 82 lakhs.
Please come to the order.
At paragraph number 7, she has stated in her application,
Please read.
may I bring your lordship's attention to page number 100, the application.
Take the order and go to
Order,
the-
yes, yes.
Yes,
From the top, your lordships.
yes. From page number 20, paragraph number 7.
The petitioner is the husband of the applicant respondent. Filed the application under section 7, 9, 10, 11, and 12 of the Guardians and Wards Act, thereby seeking custody of the minor child, Master Ryan, of till attain the age of majority. So it could be held that the minor child is now definitely in the custody of the respondent mother. It is stated by the petitioner that the petitioner married the respondent on so and so date as per the traditions. It is also stated that the petitioner, in the said matrimonial life, the respondent had conceived and gave birth to the child, boy baby, on 21.
Where is the discussion about the financial capacity of
No,
both the
assets and liability was not filed at all, your lordships. And another issue is that I had filed IA number 7, seeking visitation rights.
1 minute. Okay, what do you say? What is this order?
Let's, assets and liabilities were not filed before the family court, please, lads. Lads, it was filed on 27/2/2019, please, lads. These two applications I have made. I had
No,
filed, please.
when the court is granting such an exorbitant amount as educational expenses, and also 20,000 as maintenance, the court has to discuss what is the financial status of both the parties. Without doing it, what is this order?
They did not even file objections for my applications.
Where have you filed? Where is your financial capacity is discussed by the court?
Let's see, in para 8.
Yes,
Let's-
read para 8.
On the other hand, the applicant respondent took the contention that the petitioner had deserted her and her child and did not provide anything to their livelihood apart from it towards meeting the education expenses of the child Masteria. The petitioner fails to object the said contentions taken by the respondent in the application. When there is no dispute with respect to relationship is concerned, apart from when there is no dispute to the born of the child in the said matrimonial
See the
relationship.
entire paragraph.
Yes.
That paragraph is on something. When the court is granting maintenance without discussing about their financial aspects, if he has not filed the statement of assets and liabilities, court should have recorded it that he has not filed.
No,
Has she filed?
Well, in GNWC, he did not file assets and
Has
liabilities.
she filed?
No, my lords.
Then how the court will decide?
In DV proceedings, we have filed.
What is her income per month?
No, we have not sought for any maintenance for wife.
Not about wife.
No, for child.
I'm asking what is the salary of the mother?
As of now, she is unemployed. She is removed from the company, please, lads. Now the company, the employer.
Who is earning 82 lakhs per annum?
No, my lads. He is saying false.
No, the same document.
No, ask your client that what was her before being
Last
removed.
last paid.
Last paid salary. What is it?
Last paid salary.
May I make one submission?
Per month. 4.5 lakhs per month.
And when is she removed from service?
Less.
When is she out of employment? From when?
Last 2 months.
Why? What happened?
That the project, I think, the employer has removed
Yes. No, when is this petition filed? When is this impugned order? This impugned order is passed on. What is the date of the impugned order?
Date of.
Millets, wherever she was working.
20.
The husband.
26 September 2022.
We'll go into that. 26
In fact, he is the main cause for removal of her from the employment.
That we'll go into.
Please.
Now, 26/8/2022, she filed she got this order.
Yes, please.
How much maintenance she sought for the child?
Millets, applications.
She wanted 12,14,870
Yes,
and
please.
20,000 towards maintenance of the child.
Yes.
Her salary is 4 lakh. What did you say? 4 lakh?
4,50,000 around.
4,50,000. And where did she assert about the husband's income?
Millets, I'll.
Where did she say?
Millets, kindly see my statement of objections, please. Millets.
Yes.
Annexure R9, please, Millets.
Sir, volume number, sir.
Volume, no, only one volume. Statement of, that is.
Yes.
Annexure R9, Millets, he does not produce latest bank account statement, latest ITR returns, nothing.
That we will
Then
find out. I
we-
asked you a
we-
question.
Millets.
According to you, what is the salary of the husband?
Yes, please, Millets. We were constrained to file an application under section 91 of CRPC.
What you can tell
So
me the
based on
figure.
that, this account
What
statement
is
was
that?
called
What
for.
it says?
Millets.
What it says?
Please, Millets. He has got 1 crore 53 lakhs at a stretch. Millets, can you kindly see page number 253. 253 of my statement of objections. He is a software engineer, please, Millets. On 12th December 2024.
That is one aspect. What is his salary as per this?
He does not produce any salary slip, please, Millets. He is working as software engineer.
Said, some information you have obtained under right to information. What information?
No, not under right to information, please, Millets. This statement of account pertains to petitioner was called by the.
I will set aside this order and the family court decide all this by taking the assets and liabilities.
No, Millets.
And let him pay the 10,000. We will see about the 20,000. We'll see about now in the change of circumstances.
My lord, as
Whatever
per the
she
interim order passed by this honorable court, he has deposited at the rate of 10,000 per month. But he has not at all paid education expenses.
Not 10,000, let him pay 20,000 per month. But
No, let him pay,
educational.
let him pay 10,000, please, my lord. But let him pay 50% of the entire education expenses. I have produced the entire documents, education expenses,
No.
school receipts.
For example, his salary is 6 lakhs. You will put a child in a school where the school expenses are 2 lakhs.
Please, 20.
Then
On
where-
7/3/2025, I have produced entire school receipts. Please, my lord.
For that, the court has to determine, just like that, we cannot direct. We can't direct the court.
Let him pay 10,000 per month. And let him pay 50% of that. On 7/3/2025, I have produced the entire receipts.
Whether joining a boy in the particular school, have you consulted the father?
He is settled in Germany with his second wife.
That's what they've been
Now,
saying, your lordships.
and
They've been made,
kindly see.
from the inception, they've made unscathing and unwarranted allegations against the
Kindly see
petitioner.
this order, which is passed last week by the DV court.
Even as we speak, there are 8 pending proceedings between the parties.
I had made an application to call for his passport to ascertain his travel details, please. There are 6 of this order, please. There are 6, please. Perusal of the records reveals that the respondent has filed his bank statement only till
Where are you reading
2014.
that?
There are 6 of this order.
This order has only para 5. There is no 6.
So it is.
New one, which one did you do?
Yes.
Which side?
Why you are not filing the documents before
Your
the
lordships,
court?
whatever document that I could obtain from the petitioner that I have already filed. And
Not
I've
about
also
you could-
filed my ITR.
It's not about you could obtain. Petitioner has a duty to give those documents to you.
Bank statements I have produced, your lordships. I have given to them already.
Then what
And
is
also
this order?
ITR.
Have you questioned this order? That's passed.
No,
by
I
the
intend to
court?
question that order, your lordships.
Which is where, when
Which
is it
was
filed?
recently, last month, it was passed last month.
Anyhow, now, without going into all this, as it is the order that's passed by the court, without any basis, without any reasoning, these kind of orders cannot be sustained. This is not the way the orders have to be
2.5
passed.
years, he did not file even objection.
Please understand, Mr. Counsel, we are not on the facts of the case. We are not about what is happening between the parties.
Please.
I'm only concerned with the impugned order. Impugned order is bereft of reasons. Nothing, no exercise is done by the court. And I can understand the school fees of 10,000, 50,000, 40,000, something court has granted. It is running into lakhs of rupees. Court first should have seen what is the capacity of the mother, what is the capacity of the father, isn't it? Then proportionately, there should be contribution. And first of all, for example, for husband's salary is 2 lakhs, wife's salary is 4 lakhs. Why should it be 50-50%?
He is not revealing at all about his.
That is the other aspect. That's what I'm saying. And we are not going into all that. This impugned order cannot be sustained for the reason that the court has not considered any aspects while granting such exorbitant amounts. Let him pay 20,000 till.
20,000 will be very difficult for him.
Why?
10,000 he can, I'm voluntarily I've been paying 10,000. I don't mind
Not
paying
voluntarily,
10,000.
please.
But
Well,
20,000 is,
condition.
your lordships,
Subject to
even.
condition, not voluntarily.
Come. Agreed with orders passed in. I number. What is this IA pertaining IA number 8 and 9?
IA 8 is with respect to school fees and IA 9 is with respect to paying maintenance at 20,000 rupees. And one more submission, your lordship. I had filed IA number 7 for visitation of rights, seeking visitation of rights. That is still pending even to this day. I had addressed my argument with respect
to do with that. Now we can't decide everything on something else.
No, but direct.
Should have asked. No, we will not pass any direction.
Your lordships, I've been
passed in I number 8 and 9 in GNWC
He did
number
not press that application.
I've been pressing the application.
2017, dated 26/9/2022, whereby the court had granted whereby the court had directed the father to pay the entire educational expenses of the child and also directed to pay maintenance of an amount of 20,000 per month regularly until further orders. The respondent mother has filed their application 8 and 9. One is to pay the amount of rupees 12,14,870 and the other is for 20,000 per month as maintenance. The court had directed the father to pay, and this court has perused the order that is passed by the court, except stating that it is the responsibility of the father to take care of the child. Nothing has been stated by the nothing has been discussed by the court. Court has failed to discuss about the financial capacity of the father, the financial capacity of the mother. Learned counsel for the petitioner submits that the mother is earning 4.5 lakhs per month, and his salary is.
His salary is 6 lakhs per annum, Your Lordship.
His salary is 6 lakhs per annum. And the court, without considering all these, had passed the order.
That is last paid salary.
I will, that is his contention.
Contention.
Oh, I'll record your contention also.
Please, please.
Learned counsel appearing for the respondent submits that from the last 2 months, she's out of the job. And it is because of the acts, it is because of the acts of the husband, of the father. It is submitted that now she is unemployed. Next one. Having heard the counsels on both the sides, peruse the material on record. This order is passed in the year 2022. In the year 2022, the mother's income is 4.5 lakhs per month. And she is seeking 20,000 maintenance to the child and asking the entire educational expenses to be paid by the father. When such an application is filed, court ought to have considered what is the income of the father, what is the income of the mother, and what should be the contribution of both the parties to the child. The court has failed to consider any of these aspects and simply considering the fact that he is the father and he has the responsibility, had directed the father to pay the amount. The said order cannot be sustained, and in fact the court had failed to follow the guidelines issued by the apex court in Rashish versus Neha. And in that view of the matter, this court feels that the order of the court as far as granting the educational expenses needs to be set aside, whereas the amount of 20,000 that is ordered by the court shall be, this court do not find any reasons to interfere. Accordingly, the court is passing the following order. The order dated so and so is set aside. It is as far as the educational expenses are set aside, and the matter is remanded back to the trial court. Within 1 month from the date of receipt of the copy of the order, both the parties shall file their statement of respective statements of assets and liabilities as envisaged for the Honorable Apex Court in Rashish versus Neha, and within 1 month from there, the court shall decide the application. As far as 20,000 is concerned, the petitioner shall continue to pay 20,000, even if the arrears are there. The arrears also
4 months arrears
shall be paid within a period of 8 weeks.
20,000 may be reduced to.
In the year 2022.
It is submitted that in the year 2022, when the order is passed, she is drawing 2 lakhs, and at present, before the last pay, before she lost the job, is 4.5 lakhs.
Your Lordship, 20,000 may be reduced to 10,000. And may I make one more submission, Your Lordships? IA number 7 may be disposed along with IA number 8 and 9.
Come up with the petition, then we will see.
Cell number
That has-
15, Moinuddin.
Fair for respondent.
Petition this case.
Yes.
I'm ready to join with the respondent, Your Honor. I'm ready to accommodate her. But meanwhile, we have requested them to withdraw all the cases, except this case.
What are the other cases?
Criminal petitions are there against my parents, Your Honor. DVAC pending before the
How many cases are there?
2 cases.
Let her withdraw, except this GNW.
My respect to submission, Mr. My lord, even my lord, as per my lord, previous my lord conciliation, my lord, since my matter may be pending, my lord, before this honorable court.
This matter will be pending.
Please, my lord.
This matter will be pending and it is arising out of the GNWC. GNWC and this would be pending.
No, very submission, my lord, because they have taken, submitting before the trial court, my lord. That's my trial court disbelieve, my lord, their defense, my lord. Then, my lord, even though, my lord, what my lord, if I'm saying that, my lord, I have to withdraw the petition. No, my lord, kindly see, my lord, they are already, trial is going on, the matter is posted for cross-examination before the criminal matter, my lord. Cross-examination of the.
What is that you will get by convicting them?
No.
You want to join.
Please,
You want to
Manoj.
join.
Please.
And you want to continue those cases and join here.
Let
and,
us-
and the in-laws and the husband should be convicted in a, or you make your all efforts to get him convicted in that.
My lord, not like that. My lord, he may be undertake to, my lord, file an affidavit saying that, my lord, he will not give any trouble to the respondent, my lord.
I can.
He will not give
Any trouble, my lord.
then he will give a undertaking and court will monitor that.
No, my lordship, they are very, what, my lord, before the tribunal, very same submission they are making, my lordship.
What we'll do is, let this go on for some time. The matter is pending before this court, let it go on for some time. Then after that, we'll ask them to file that, to take that steps of, withdrawing the cases and all.
What happened earlier?
Let it be, let it go on for 2 months. Because with all that happened in the past, they have their own apprehensions. You have your own apprehension, isn't it?
Yes, yes, sir.
We will see for now, we'll list these matters on 25th of September.
August itself, Your Honor. Because what happened, Your Honor? Now, next month, my sister marriage is there, Your Honor.
So,
because she's going.
till such time, I will undertake that all those proceedings will not be taken forward.
Yes, Your Honor.
It is both the parties, that I'll record. Till such time, till the matter comes up on the next occasion, either any of the matters that are pending between the parties, it will not be precipitated.
Highly obliged.
So what is it? What is he going to do now?
I will accommodate, Your Honor, in my hometown.
You will take a house there. When are you going to take?
Just let me check the party.
You should have checked it.
Because
That's what order has to be passed.
yes, sir.
Talk to him. Yes, next. Call the next case.
Kindly
Petition number 16, disposed 17. Sudarshanel.
Petitioner husband, my lords. The maintenance with regard to the kids, my lords, 25,000 each. My lords, no doubt there, both of them are British passport
Come
holders.
to the imprint order.
Input order on page, my lords, page 47, my lords.
Yes.
The husband is hereby directed to pay sum of rupees 25,000 per month each to
25,000
petition number.
per month each petition number 2 and 3. That is 50,000.
Correct. Correct.
What is your income?
My lords, my income, I will come before coming to that, my lords. I was working in UK, my lords. 2005 we got married. So my family was shifted to UK and she also became the British passport holder. Then the kids were born there. My lords, in 2016 there was a my lords, there was a complaint on me. There was a dispute, my lord. The complaint before the UK government. Then I had to relocate back to India. She has taken the citizenship, my lords, and also she has taken a job, and government of UK is supporting her by giving education to the kids, shelter, everything. Now,
Where is she now at present?
she is there. Her father, she has given a GPA and she files a complaint in Mysore court, and she's claiming the maintenance here.
You are in India.
I'm in India. I relocated from 2016, my lords. I came back because I had to, with that complaint, I had to come back. I had to stay back with my mother now. My brother-in-law.
First file a GNWC.
I have filed that. I have filed in Mysore court.
So in that GNWC, they filed this IA. For
No, my lords.
maintenance.
In MC matter, divorce matter, which I have filed, my lords.
No, this is arising out of
This is arising out of the.
criminal miscellaneous.
Yes.
She files a criminal miscellaneous.
Yes. My lords, and she has filed a restitution of conjugal.
Children are aged about 12 and 8. Education is free.
Education free, shelter is given, my lords. All everything they have taken. The court says additional education on that. That this is not. My question is that. What is that additional education? The order says.
Land counsel for the petitioner submits that the wife husband along with the kids were residing in UK, and as the wife has given a complaint, he was forced to come to India in the year 2016, and ever since he is residing in
India, Bangalore.
Bangalore. Then after coming here, you have filed the MC for divorce.
Please.
He has filed the MC for divorce and GNWC seeking custody of the children. Wife had filed criminal miscellaneous seeking maintenance. And by order impugned, the court had granted, in I number 2, the court had granted maintenance of an amount of rupees 25,000 per each to the children. And as far as the claim of the wife is rejected, Land counsel for the petitioner submits that the wife is working in US, in UK, and both the children are having free education and everything is taken care of. He is residing in India. And what are you doing?
I'm right now jobless, man. Some small job I'm doing where some consultation like that I'm doing.
Statement of assets and liabilities.
Yeah, I have
of
produced the same thing I've taken.
He submitted that he is jobless and he is doing some small assignments and eking out his livelihood. The court ought not to have granted 50,000 as maintenance for the children who are in UK. It is submitted that the wife has staying in UK gives a GPA to the father and files this case. Considering the submission of the land counsel the petition, they shall be stay of all further proceedings. And so and so, so and so. The petitioner is permitted to take court hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. And to that effect by 13th of August. If the memo is not filed, the stay granted by this court stands vacated.
Please.
Yes, next.
Till number 18. PM Sidmalappa for petitioner.
This case appear for petitioner, please. This amendment filed by the husband. It is rejected by the trial court.
Let us see.
It is in page number order. It is in page number 47.
47. Let's read the order.
The respondent has not filed the objection. The petitioner, the husband, has filed the main petition seeking a dissolution of their marriage, both based on the cruelty and desertion. The petitioner is in his petition has specifically contended that on the 18/6/2020, the marriage of himself and the respondent was sound-based and only about 2 months they could spend time together. The petitioner in his petition has contended after some time by third party he came to know that the respondent conceived and the respondent did not reveal the same to him. Now the petitioner has come up with the present IA seeking the incorporation that he is not the biological father of the child. The petitioner is in his affidavit has sworn that he was under the impression that the matter would be settled as such. He could not include the said fact in his main petition. It is clear in his petition the petitioner has not disputed the marital facts, but now that the present IA is trying to incorporate he is not the biological father of the child born to the respondent. I am of the opinion that if the amendment application is allowed, certainly it would be amount to withdrawal of the admission. Now the case is posted for
This is order number, now you are questioning IA number 8.
Please, Lordship.
Oh, yes.
In my petition itself, Your Honor, I request this honorable court, in my...
For the husband.
I am appear for the husband. In page number 15, the...
1 minute, 1 minute. What was your earlier pleading?
The same pleading, Your Honor. I have taken a contention that I request this honorable...
Is it your case that, no, at what stage this is filed?
It is at the time of the cross-examination of the PW1, Your Honor. Finishing the cross-examination, I filed the present application. Here, I request this honorable kindly request in page number 15.
Complete reading this order.
In 15, may...
Tell them.
Para 9 of my petition, please, Your Lordship. In page number 15.
1 minute. No, please come to your objections. MC is filed by you or her?
Me.
Where is your MC petition?
It is in page number 14. I request this honorable court, para 5, 6, 7, 8 and 9, please, Your Lordship. Para 5, please, I may be permitted.
Yes.
The petitioner and the respondent are working in a private company earning a good income, and it was informed by the respondent to the petitioner that she had no desire to marry the petitioner, and the said marriage was done forcibly as per the wishes of our parents. The petitioner submit that that the respondent did not have any desire and they did not full desire and the duty as the wife of the petitioner. The petitioner submit that after the marriage, the respondent used to go to the house of her parents and they would not return for many days without any reason and just the cause and did not return to the house of the petitioner. After the intervention of the elder from both the side of the petitioner and the respondent family, the respondent did not show any desire to return to the house of the petitioner, and it was informed to the petitioner and his family member that the respondent she did not willing to go back to the house of the petitioner.
You have never taken such a
Para
stand.
9, please.
As far as I've seen that.
The
You have not
petitioner-
stated anything with regard to the character of the wife.
My humble submission, Your Honor. In the para 9,
I've
I
read it.
specifically, after a few months, it was informed by the third party of the petitioner family that the respondent is conceived
Yes.
and not informed to the, my humble submission, Your Honor, enter my petition immediately after the marriage, after 2 months,
You
she,
cannot read your para number 9 in isolation. It has to be read along with para number 8. According to you, on and off, sometimes she is here, sometimes there. You have narrated in such a way that important factor of being she conceived was not informed to you. That amounts to cruelty according to you. You have not raised any suspicion with regard to her character.
my humble submission in her objection also, she cannot say, she directly denied that my contention, and she admits that the desire more than after marriage only 3 months, 2 or 3 months she is staying the petitioner. After that, the marriage was solemn, please Lordship.
What is the date of the birth of the child?
18/6/2020. It is a marriage. The birth of the child, it is not referred in the affidavit, and she is not also filed the objection to my application also, and she is not referred anything with regard to my application. Here, my humble submission before this honorable court, Your Honor, I have taken that.
When did you realize that you should take that objection after the cross-examination is over?
Well, at the time of cross-examination, I have elicited that fact before the court. Before the court, they have suggested that I am elicited before the court in the cross-examination. And immediately I have filed this application, please, Your Honor. Here, my humble submission before this honorable court, Your Lordship. It is a burden on the petitioner. He has to be established, Your Lordship. Here, my humble submission, if he is not correct, certainly she filed the objection and she is restricted. She has not filed the objection. With regard to para 9 is concerned also, she directly denial, only denial. She has not stated anything with my divorce petition. She has not taken any steps with regard to my here, my humble submission, Your Honor, it is not changing any nature of the petition, please, Your Lordship.
Yes. Any other submission?
This is the amendment. Amendment can be allowed, please, Lordship.
Kind of amendments
My humble submission before this honorable court, Your Honor, if the amendment is permitted, if amendment is also permitted, it is a burden on the petitioner. Petitioner has to be take a legal.
It is correct. Burden lies on you.
Please. Enough that it cannot be arms to the respondent, please, Your Honor. If she has got every right to deny the said only that word, and if I am not proved, Your Honor, the court cannot consider that also.
Please come. Agreed with the orders passed. I number 8. I number 8 in MC number 5246 of 2022, dated 3/5/2025. The husband is before this court. Husband has filed MC number 5246 of 2022, seeking divorce on the ground of cruelty. The petitioner has stated about the manner in which the wife was behaving and how rudely she's behaving with everyone. And as a petitioner could not tolerate her behavior, he has come up with this petition. Where after the cross-examination of the petitioner husband is completed, at that point of time, he has come up with the instant IA, I number 8, under order 6 rules, seeking amendment of the pleadings. Now, by way of this amendment, he wants to incorporate that the petitioner is not the biological father of the child. And according to the petitioner, it would not make any change, nor the relief that is sought is not changed. The court, by order impugned, had dismissed the petition. While dismissing the petition, the court observes that it is clear in his petition, the petitioner has not disputed the material fact, but now with the present IA is trying to incorporate that he is not the biological father of the child born to the respondent wife. Hence, if the amendment application is allowed, certainly it would amount to withdrawal of admission. Now the case is posted for the respondent side evidence. So the court of the view that as a husband did not deny that he is not the biological father of the child in his original petition, this amendment cannot be allowed and accordingly dismissed. Next part. Learned counsel appearing for the petitioner has drawn the attention of the court to the pleadings, particularly paragraph number 5, 6, 7, 8, and 9. This is at page number 15, extract. Particularly, drawing the attention of the court to paragraph number 9, Learned counsel submits that after a few months, it was informed by third parties or the third parties to the husband's family that the wife is conceived and it is not informed to the husband. Relying on this paragraph number 9, Learned counsel submits that already he had laid a basis for this pleadings in IA number 9, but the same was not elaborated. It is submitted that it is very much essential for deciding the dispute between the parties. Further, by incorporating these pleadings, the nature of the suit is not changed. No prejudice is caused to the wife. Further, the burden lies on the petitioner to prove the stand. As such, the court ought to have allowed the amendment. Anything else?
In para 13 also, that is a specific reference.
In 9 and go to para 13 also.
13 and 14.
13 and 14 also extract.
13 specifically I have taken a contention, Your Honor. We are,
This is in that along with that till 9 you have extracted. Extract 13, 14 also. And hence the court, Learned counsel submits that the court ought not to have dismissed this application, which is very much crucial to the case of the petitioner. Next part. Having heard the counsels on either side, counsel for the petitioner, but it's the material on record. The petitioner has filed, the petitioner husband has filed the MC seeking divorce. The whole basis for that is cruelty. But in the petition, he has narrated the adamant nature of the wife and how often she is staying away from the matrimonial home and how rudely she is behaving with the family, with the husband and the in-laws. In paragraph number 9, it is stated that she has not even informed about the fact that she conceived, and they came to know from the third parties. Then in paragraph number 13, it is stated that for outside world, both of them were living as husband and wife, but within the four walls, they're living as stranger and living separately from last 2 years, and the wife is not willing to live as the wife. And there is no cohabitation between them. And since some months they're living separately. Even after the husband and his parents tried to pacify the relationship, and there was many panchayats are held in the presence of the elders and well-wishers, but all the efforts went in vain. Hence, the husband had filed the petition. At any stretch of imagination, this court cannot believe the submission or accept the submission of the learned counsel of the petitioner that already he has laid a basis in the pleadings that the wife is living in adultery and the child is not, he is not the biological father of the child. Reading of the entire pleadings in the pleading.
Adultery anta ello petition alli heli.
Then if you are not the biological father, somebody would be the biological father.
That word I am not used in
Not
the
used, you have not even stated anything.
in the affidavit also.
The husband, what did you write? Is not the biological father of the child. He only, the entire petition is filed about the act of cruelty on the part of the wife. And now, by way of this amendment, saying that he is not the biological father of the child, the petitioner is setting up altogether and do a different case and trying to, by virtue of this amendment, is now the admission that he has made all through. Now is going to take away such important admission after the trial has commenced. In those circumstances, the court had rightly decided the issue and this court do not find any reasons to interfere. Accordingly dismissed.
Number 19, consistently by petitioner.
Yes.
Appear for petitioner, my lord.
In this matter, my lord,
I
they have
present
just
husband.
served the copy to me. I have preferred a writ petition. It had come up yesterday. It is posted to 5th August, my lord.
This petition may kindly be tied with.
Post this matter along with, give the number. So with
On the last date of hearing, we mentioned, my lord, it is listed, both the cases to be listed today, but their case is not listed.
No. I said to list this along with that.
Please, my lord, on the last date of
Anyhow,
hearing,
that
please, please.
whatever the number, list along with that. Take that number.
Right.
Yes. Yes, next. Yes.
Cell number 20.
Yes.
Cell number 20.
Please, my lord, I appear for petitioner.
For 2 weeks' time to place my
No,
objections
my
on
lord, there is
record,
an
my lord.
urgency. The impugned order is at annexure M.
Impugned order. As far as the interim order is concerned, you can't have any objection. If you can't come, your objections are not necessary.
My lords, the reason being that the reasons that they've stated for coming before this court, the same has been alleged in the maintenance petition as well.
You argue, you can't seek time. You will be heard because
My
you made
lords,
the
my
caveat.
senior is also unwell, which is why I've not been able to seek instructions from him as well as from the client, my
No,
lords.
it has come yesterday.
My lords, he didn't appear yesterday, my lords.
That's what, it was there yesterday because it's a 25 matter, it is listed today. No, if they have an urgency for interim order that you can't stop, court will hear it first. Yes, where is it?
Please, my lord, annexure M is the impugned order, page 73, which is 73, annexure M. My lord, which
It
is
is 73, not 73.
annexure M, my lord.
It starts from 75.
Please. No, there is some pagination is, in fact, it was earlier, it was RPFC was filed and it was.
Directed to pay interim
Please.
maintenance of 15,000 per
Please,
month.
please. There is no discussion about the assets and liabilities.
1 minute.
Please.
Each both to his wife and his son from the date of IA pending disposal of the petition. So that means 30,000 per month.
30,000 per month. However, my lord.
Discussion part.
Pardon?
Which court is this?
In Haveri.
Pardon?
Which court is this?
No,
Principal
criminal
Judge
miscellaneous petition under section 125.
6th additional. When is
Please.
this order passed?
Order is
24th
passed on
April.
24/4/2025. 24/4.
Happening to them. Why are they passing these kind of orders?
Please, my lord, there is no, absolutely, there is no discussion about the assets and liabilities. Both the parties have filed. In fact, my lord, the petitioner has filed his bulky of documents along with his statement of objection to the IA.
This order to the R&S. How many times they have told?
No
When will they
discussion
do
at all,
this?
my lord.
Your
No
Lordship,
judicial
para number 4 of the
consideration.
order, my lord.
What is this? Since the respondent himself has agreed to pay monthly maintenance of 45,000 both to his parents, if he is directed to pay monthly interim maintenance of 15,000 each, what is this?
Please, in fact, what happened is, my lord, the parents are very age-old parents and suffering
You're
from
contributing 45,000.
contributing. They are living separately.
That's what you're contributing 45,000.
45,000, I have produced the medical bills also. Along with this petition, they have undergone operations.
What is your salary?
My salary is 70,000. Gross
No,
salary,
your salary is 70,000.
70,000.
In that you pay 45,000 to
No,
your
earlier,
parents.
no, please. Earlier, he was paying 30,000 to the parents. It was enhanced to the 45,000 recently
By whom?
by the petitioner husband, by the petitioner earlier.
Earlier you're paying 30, now
That-
you're paying 45.
45,000, they approached.
What is left with you?
Yes, my lord, that is what my contention, and the remaining amount is very meager amount, only 10 to 15,000, my lord, I may save per month, apart from my expenditure. In fact, my lord, I have paid the school fees of my son also. Last year, I have paid 60,000 school fee, and this year also 30,000 school
I
fee.
not say that I will give 45,000 to my parents, sir, but I will not take care of my children.
No, I will take care of my son.
Pay peanut
In
of
fact, my lord, as
5,000.
per the assets and liabilities, she is also earning. She has a tailoring and boutique shop. 30 to 40,000, she is getting the income from that business. And apart from that, my lord, she is having a rental income. And what happened is, my lord, my lord, is the petitioner herein, has invested a money to construct the building. And he has invested more than 50 lakhs rupees for construction of,
You continue to pay 10,000 to both the children. Will remand this
not
matter.
10, my lord, 15,000 in total.
Will remand this matter and let the court decide basing on statement of assets and liability.
May I make one submission? 15,000, my lord, 10,000 and 5,000. 10,000
My
to the
lords, no,
wife
my lords.
and
The
5,000
son is
to
a
the
minor son, my lords.
5,000 to the son, my lord, because
8 years of age, my lords.
He
School
is paying
expenses
the
plus
LIC
medical expenses, my lords.
LIC premium 15,000 he is paying per
Moreover,
month
they
to
have
the
filed
son.
a suit OS for the very property they are alleging that I'm getting a rent from, my lords.
Last one, I number 3 in criminal miscellaneous number 1028 of 2023 dated 24/4/2025, whereby the court had granted 15,000 each both to the wife and son, that is 30,000 per month. The husband is before this court. And counsel appearing for the husband submits to the court without any discussion, without looking into the statement of assets and liabilities. Whereas it is a case of the husband that the wife is earning, the court has passed this order. Land counsel appearing for the respondent, land counsel appearing for the petitioner submits that he is contributing an amount of rupees 40,000 to his 45,000 to his parents, and is left with a very meager amount, and it's difficult for him to pay an amount of rupees 30,000 as maintenance. The land counsel appearing for the respondent submits that only to avoid the payment of maintenance to the wife, the husband has come up with such a plea. It is submitted that he is capable of paying the maintenance, and the court had rightly granted the amount, and there are no reasons to interfere. There are no grounds to interfere with the well-considered order passed by the court. Having heard the counsels on either side, peruse the material on record. It is so unfortunate that in spite of repeated orders that are passed by the court, passed by this court and passed by the Honorable Apex Court, and as well as this court, the courts are not following the judgment of Rajneesh versus Neha. In several judgments, this court do not find
Your
any
lordship,
consideration.
one submission, my lordship. The assets and liabilities were disclosed, my lords. In the para 4, it has been considered by the court before.
Consider.
My lords, both the petitioner number 1 and respondent have filed their affidavit of disclosure of assets and liabilities. Both the petitioner number 1 and the respondents reveal that they have no job. The petitioner number 1 in her affidavit assets and liabilities reveal that she has completed BBM. The respondent in his affidavit of assets and liabilities revealed that he has completed BE. The petitioner number 1 has contended that the respondent is having sufficient income from his salary and other sources. The respondent has furnished the order copy passed in criminal miscellaneous so-and-so on the file of the principal judge, Family Court, Haveri. On perusal of the said order, it is clear that both the parents of the respondent have filed maintenance case against the respondent, and the respondent and his parents have filed the joint compromise. Accordingly, the said case has been disposed of. The joint compromise memo furnished by the respondent side make out that the respondent has agreed to pay monthly maintenance of 45,000 to both his parents. The respondent has contended that the petitioner number 1 is having a rental income and she also has income from other business. Since the respondent himself has agreed to pay monthly maintenance of 45,000, both his parents, if my lords, but they have considered the
File your statement of assets and liabilities. Court has to discuss it.
No discussion on that.
When it is his contention that you are earning, you are having so and so, what did you state in your statement? That the court has to understand from this order.
indeed, my lords, but
Without
if
doing that, the court can't just like that say, because he's giving 45,000, okay, he's giving 45,000, what is his income? He's giving 45,000, what will remain? All those are to be the discussion. When he is saying that you are earning, court should give a finding that according to him you are earning, you have filed your statement of assets, court has perused everything and you are not earning. There should be a finding on that. What did you write? In several judgments, this court is coming across several judgments where there is no appreciation of facts in the light of the law laid down by the apex court. The judgment referred to supra. And in several matters, this court has sent those orders passed by the courts that to remind that the judgment of Rashish versus Neha is not followed. In this case, though the learned judge refers to the judge's statement of assets and liabilities, but what is if it is a case of the wife that the wife is earning, there should have been a finding that basing on the statement of assets and liabilities, whether she's earning or not, whether there is any income to the wife or not, what is husband's income? He paying an amount of rupees 45,000 towards the maintenance of the parents, that itself cannot be a ground for the court to pass an order directing to pay 30,000. The court ought to have passed a reasoned order basing on the statement of assets and liabilities and looking at the financial capacity of both the parties. In that view of the matter, this court deems it appropriate to set aside the order dated so and so and remand the matter to the trial court to the family court.
your lordship, one clarification, set aside incomplete or 10,000, 10,000?
Just listen to the court's order, let it complete, set aside the order and they will remand the matter to the trial court. Pending disposal of the petition, the husband shall continue to pay 20,000 per month.
May make one 15,000, my lord, make it 15,000 because
the-
10,000 to
My
the
lords,
wife.
please, my lords.
1,000 per month. And if there are 20,000 per month, if there are any arrears at 20,000, that also shall be filed within 4 weeks. The court shall dispose of the matter basing on the statement of assets and liabilities by passing a reasoned order within 2 months from the date of receipt of the copy of the order.
Grateful, my lords.
Case number 21, Kumara KG.
As per direction of the Honorable Court, my lords, you have served the copies to the respondent, counsel, my lords, day before yesterday. Because this matter was listed day before yesterday, my lords.
Where, to whom, to who is the counsel?
My lords, we have served Advocate Srimati Neelofer R.
It is submitted that. Memo, have you
I
filed the memo?
Memo filed.
Land counsel for the petitioner submits that as per the order of this court. They have served the papers on the counsel. Nilofer R. On
23/7/2025.
23/7/2025. Yes, what is the order?
My lords, order is, my lords, passed recalling, my lords, we have filed for application for recalling and reopen the, my lords,
Let's
case.
see, where is that application? Let's see the application first.
Yes, my lords. Application 13 and 14, my lords.
Page
Starts, my lords, application, page number 34, Annex D, is the application, IA number 13.
Page number?
13 is the application number 13, page number 34, my lords, Annex D. For recalling the order.
34.
34, Annex D.
Reopen the stage from judgment.
Yes,
To conduct the
my
cross examination. When is the case posted for judgment?
lords, they kindly, on the same day, my lords, page number 20, my lords, kindly see, it say, my lords, it's not speaking order, my lords, only 2-line order.
Anita. Every day this book, whatever the used things are, they should be removed and it should start with them. Yes.
Page number 20 is the order, my lords.
No, I'll not do anything. Yes.
Page number 20.
Yes, 35 I'm looking at.
My lords, the order is just page number 20.
Not that, no, we'll read it. We'll read your
Application.
application.
From the, my lords, the application, we have, first application for 13 is for my lords,
Petitioner is a wife or husband?
husband, my lords. Husband filed divorce, my lords.
Yes.
Recalling the RW, recalling order
It's
date.
an MC of 2016.
Yes, please, my lords. We have filed the MC. My lords, they wants to lead evidence of my lords witness as a RW2.
Where is the case sheet of this case? Entire docket proceedings, where are they?
Inter?
Proceedings.
Yes, my lords, this is Annexure A.
Annexure?
Annexure A is the my lords proceedings. In the Annexure A itself, my lords, the court has passed an order. There is no separate
No,
order.
it is not that. Only 2-3, not 2-3. What is happening from 2016? That I want to see.
Everything, my lords.
Huh?
Everything I have not produced, my lords. I have
That is
produced.
relevant. That is relevant. What is happening from 2016?
one-
2016 MC pending itself
Yes,
is
we have
something, it
yes.
is very alarming.
Yes, my lords. We are for the petitioner, my lords. We want to close the matter as earliest as
If
possible, my lords.
as early as possible, why, for whose reason, for whose default, MC of 2016 is pending, which the court wants to know.
Yes, please, my lords. But on the next day itself, my lords, if the court gives a time, my lords, we will cross-examine in the same
Mr.
day.
Counsel, this court is very much reluctant to
Please,
these
please, my
delays.
lords. I understand,
And,
my lords, but
this
we are-
court will not contribute, not even one.
Please, my lords, we only were requesting, my lords, same day
This
will
material,
cross-examine.
I cannot pass an order. I want to know from 2016.
Please.
How many times you have taken adjournment, how it is happening, why the matter is due. Just you will not, just like that, post the matter for judgment. We can't look at that one order posted for judgment. What has happened prior to that?
Prior, my lords, both parties are absent, my lords. I'll.
Not one time.
Lords, I'll
2016,
just-
what's happening?
Lords,
9
I'll-
years, 9 long years.
My lords, I'll just take, my lords, earlier order. My lords, the court, both parties are absent. Court has taken arguments of the both parties as a nil and my lord posted for judgment. On that day, my lords, we have filed application for recalling the RW2.
What is the reason to recall RW1?
My lords, RW have led the evidence of chief. My lords, she's a witness, she's a daughter of petitioner and respondent. My lords, she
Why
wants
you
to.
have not examined on that day?
Lords, advocate was.
Courts have so much of work. They can't wait
please.
for you.
Lords,
And,
we-
and
my lords,
every
the-
action of the trial court without any basis, this court shall not interfere.
It's so, my lords, I understand, my lords.
That's
Only,
not the
my lords,
way
on
how
same
the
day-
system runs.
My lords, on same day we'll cross examine. My lords,
I
same day
want
we'll
to
argue.
see the proceeding sheet of this case. Without that, I'll not interfere with anything. Monday, by the time the learned counsel for the petition shall place before this court, the entire proceeding sheet of.
Not Monday, my lords. You have to apply for the certificate.
Then whenever you want.
Tuesday or Wednesday.
Tuesday, Wednesday, court has no urgency.
Please.
Let's this matter on Tuesday.
In the preliminary stage, my lords.
Huh?
In the preliminary hearing stage.
Same stage it will come.
Please.
Till number
Yes.
22, K.
Bring
Ravishankar.
the name of that advocate in the cause list. Yes.
Till number 22,
And it is made clear that court has not stayed the proceedings. This court has directed the petitioner and counsel of the petitioner to replace the entire order sheet of the MC. And it is made clear that this court has not stayed the proceedings. Yes,
K. Ravishankar.
yes, please. What your client is saying?
Yes. Lordship, sir, yesterday asked me. How
What is
about
that he is ready to pay?
may little facts, because why this much of, though I can't take a shelter because I placed an ex parte. But even before
Question, that ex parte order? That ex parte order is not questioned till now.
ex parte question order has been questioned before this honorable court in
It
RPFC.
is dismissed for default.
Dismissed for default. And she has previously filed a DV Act proceedings in which 15,000 has been ordered. that is also placed ex parte. That is attained finality, and my lord, by order of this honorable court, they have deposited, my lord, that amount. That is one thing. And even in the under the 125 proceedings, without making any reference of that, 30,000 has been ordered. But the petitioner has been shown his avocation as a senior civil engineer. He is working as a mechanic. But drawing a salary of Indian rupees, when it is converted, it's a 75,000 rupees. But he has in all, but from 2021, this day, he has paid 16,16,675 rupees as an arrears of maintenance towards the 125 proceedings. Out of 32 lakhs, it has been paid. Once we will pay 1.5 lakhs. He has don't have any much source of income. But he has got operated in the year 2023. He could not come back. But now the
Paul, he should come to the court. Where is he?
he is.
Paul, he should appear before the court.
Yes, yes, he will appear.
When is he appearing before the court?
Please, Milord.
You tell a date. On that day, he should appear before the court.
Yes, by
Condition, on that condition, we will, two conditions.
Yes.
One is that amount of 2 lakhs to be deposited
yes,
before the court within so and so time.
very
And on so and so date,
yes,
he should appear before the court and undertake whatever undertaking the court asks for him, because his previous record appears to be not with all these ex parte orders dismissed for default. He is not prosecuting the litigation. He is not appearing before any of the
I
courts.
have conveyed him all things.
He is not
If you
appearing
could, if
before-
you could have been a diligent, this order could not have been passed at all.
Exactly. So now you tell the court a date, find out from your client when he will appear. On that date, he shall appear, he shall pay so and so amount.
Yes.
On both these grounds, conditional order, or else this will come into
Last may have it on Monday.
Monday. This is matter on Monday. By the time the learned counsel, the petitioner shall get instruction
Public.
that the amount when he is amount of 2 lakhs when he is going to pay, and when is he going to appear before the court? Please. Yes.
Cell number 23, Raghavendra A.
Milord, for petitioner, Milord.
Yes.
Milord, this petition for the for a speedy disposal, Milord, for a mandamus, Milord. Milord,
Which court is this?
Milord, this is Chelkere, Milord. Senior Civil Judge Chelkere, Milord.
1 minute. MC of 2021.
Yes, Milord.
Principal Judge Family Court. No.
Yes. Milord, for a moment, Milord. It was filed before the Tumkur Principal Judge Family Court, Milord. Later, which was transferred by the order of this Honorable Court on 26/2022 to Chelkere Court.
When was it filed before the Tumkur Court?
25/1/2021, Milord.
It's a 2021 matter.
Yes, Milord.
The present writ petition is filed seeking the following payer. This is an MC of 2021. The courts at Bangalore are disposing the matters, are on the task of disposing the matters till 2019 by December 15th. Hence, this court cannot pass any order
Milord,
to the family court to dispose
one
of the
submission,
matter,
Milord.
which is of the year 2021, and this court finds no reasons to interfere.
Milord, one submission, Milord. One submission, Milord. Okay. Milord, it was posted for cross-examination of petitioner on
Whatever
6/1.
it is, there can't be a direction from the court. Yes, Nick.
Cell number 24, adjourned. 25. G.
Yes.
Sukumaran, Ram.
Yes, he was morning mentioning that it has to be sent for mediation, correct?
Last time, my friend has submitted for exploration.
Yes.
I brought my client, my lord. If there is the possibility of exploring any
Shall we-
settlement, my client is here, we can
Shall we
talk.
refer it to the mediation?
No,
That's what he's saying. Morning he was asking for adjournment.
no.
That he are also.
No, my lord, you caught me wrong. My friend asked me earlier to this,
No,
she
there
made a request to me
To
for
get it
exploring a
wrong,
settlement.
You were mentioning in the
Yes,
morning.
I said this matter can be referred to the mediation because my friend suggested me for exploring. I got my client from Kerala.
He says no.
If it's no, let him argue. I have argued the matter, Lordship has heard the matter, let it go on main. If it's
My
not,
lord,
if it's not
my lord,
willing to settlement for exploring a settlement,
my lord,
my lord,
another-
we will argue the matter on merit.
My lord, another matter is pending before the family court in respect of divorce. Where the mediation is failed, then the question of mediation, referring the matter to mediation, do not arise this again. Kindly go through the matter and dispose the petition.
Yes.
My friend is, last time also said it, he doesn't want interim main. Main Lordship has heard the matter. And yeah,
Yes.
I have
We'll hear
argued
it.
the matter on main.
Yes, we'll
Yes,
pass
ma'am.
orders now. Where is impugned order?
My friend has to argue, my lord. I have argued the matter.
Yes.
Yes.
Where is impugned order?
The impugned order,
If I remember correctly,
order dated this,
no, if I remember, this is an application filed under 120,
125 proceeding, my lord.
what happens is every time the matters are heard, again sought for adjournment. What is becoming is the court has to start everything afresh. Because I'm hearing hundreds of matters, I don't remember each fact every time. No, on this case, I've spent so much of time till now. According the respondent is directed to pay a sum of rupees 15,000 per month to the petitioner. Her maintenance till the lifetime as the remarriage which was earlier. Pay sum of rupees 7,500 each towards the maintenance of the daughter.
my lord, I filed a memo for calculation for children's education.
You have filed any, your appeal is also there.
I filed it.
Where is that? It's
No
only
appeal
one-
has been, no appeal has been filed.
How
by
can you know whatever as the court has granted, we will look into only that. We can't reappreciate anything. We can only look at whether the order is right or wrong.
My lord, your lordship has informed me to file the memo of calculation in respect of the
Because
children.
you have, no, where are the college expenses?
My lordship,
15,000.
my lordship, my lordship friend has said he is not pressing any of the interim, he will go on main. That is why lordship has heard the matter on merit. Entire impugned order was read it. Lordship has expressed opinion that the trial court order cannot sustain. Now you cannot come and change the plea.
The respondent shall pay sum of rupees 1 lakh towards educational expenses. What is their age now?
23-year-olds.
20.
So from 2018, 2019, 2019, 20, when they have become major,
At the age of 18.
which year is that? That I want to know. Which year is that?
Yes.
21.
21.
2021 they become major. So for the year 2018-19, for the year 2019-20, they are entitled for educational expenses.
Yes.
So that is per year how much? 1 lakh. 2 years, this is 2 lakhs. What is the amount paid till now as towards maintenance? No amount is paid.
Only 5,000 per month he has paid.
5,000 per month.
Yes.
To all of them.
Only for wife.
Yes, what do you say?
My lord,
The impugned order is bad.
yes, impugned order is, it is cannot sustainable. Lordship, I read it. It just, I just request your lordship to turn page of my appeal, annexed B, internal ink page 43. 43, my lord. Yes, I'll read it for your lordship reference. The memorandum of an agreement under section 89 of the Code of Civil Procedure, so and so. The parties are bound to submit as follows. This petition is filed with the petition under section 12 of Red with so and so. A protection of women domestic violence, praying for a certain relief. The opposite petition was referred to the mediation for resolve for dispute between the parties during the course of mediation. They have resolved their disputes, agree the following terms and conditions. The petitioner and the respondent are wife and husband respectively. They have 2 children, namely so and so, out of the wedlock. The both now are aged about 8 years presently under the care and custody of the petitioner's mother. Now, during the course of a mediation, the respondent herein, Dr. Stanley Thomas, has agreed to deposit sum of rupees 15,000 towards the welfare of the minor children in the account of minor children maintained in X Banks of Town Branch, Bangalore, on or before 10th of each of English calendars. It is agreed between the party that the petitioner mother has a liberty to withdraw the aforesaid amount and shall utilize the same for the welfare of the minor children. This apart from the respondent stated.
This is filed under the Domestic Violence Act.
I'll just come back. Lordship, just bear me for 2 minutes. The apart from the respondent states that you won't. Yes, my lord. What happened, my lord? The recital of the gift deed I had given, it's worth about more than 3-4 crores now. And what has happened, my lord? She has settled, given up her rights, everything, and the DV Act, she settled the entire thing. And she go suppressing this material and she files a 125 proceeding. The London trial judge, without ignorant of law, she is not makes that a minor has no party there. Minor has no party there. But he awards exceeds the jurisdiction of his, without the minor, he grants an interim maintenance. And there is an ambiguity also the maintenance. What happened, my lord? I came before this lordship, matter was heard on merit. It is not an ex parte order. Now, the 125 proceeding is sustainable. But what has happened?
Counsel,
yes, my lord.
now you have read the.
I read the settlement deed, memorandum of a settlement deed. The recital of also the gift deed which was executed, that the petitioner's father has given a right to the children. They can sell, they can utilize for a future education, married, everything, the way of settlement. That is the forms of a recital of the
that I
gift.
understand. My question is, according to you, because they have entered into an agreement or a memorandum of understanding, she is not entitled for divorce. Is it your submission?
Not the divorce, my lord.
For the maintenance, for the further maintenance, she is not
Further
entitled.
maintenance, they have a provision under the DV Act for seeking for an enhancement if it is not sufficient. But that independent proceeding on 125, 125 proceedings, she has given her rights in the domestic violence. She has not claimed the maintenance.
Any reliefs that are given under Domestic Violence Act will
Yes.
not bar the relief of the party.
Yes.
That is in addition to all other reliefs they are getting.
Yes,
So
madam.
any of the proceedings
here-
that are before it won't come in there.
No, my lordship is telling the point of law, the position of the law. But whereas here the memorandum of understanding mediation, it is settled. Then there, what is the point of existing a mediation? Once and for the dispute settled, all rights are given out for everything.
That is one point I understood.
Yes, my lord.
Yes.
Now, my
Second
lord,
point.
now 125 proceeding, who are the petitioner, who are the party? The minor children are not the party before the court.
Come to that.
Yes,
Come
my
to the
lord.
cost.
That impugned order, my lordship, it gets annexed in page number 13, my lord. Yes, see the cost title, my lord. Lena Sozer, so and so, so and so. And where is that minor children have been made a party there, represented by mother?
Technical objection.
No, technically, it's a point of law, my lord. And 125 proceedings, it's very clear. Lordship knows that 125, I'll just read it for your reference, my lord. Lordship has seen it. I have not. Order of a maintenance for wife and children and parents. If any person having a sufficient means to neglect or refuse to maintain, is wife unable to maintain herself. The wife is unable to maintain herself. Here, she is a postgraduate, she can maintain herself and she has got a sufficient ground. Now, the legitimate, illegitimate children, the children also entitled if illegitimate, legitimate children, but they should be a party to the proceeding. But the trial judge has granted.
Where is your objection to this? Objection before the family court.
Family court.
Parties or they are not parties to this.
Yes.
Where do you get it?
The objection we filed before the trial court, my lord.
Where is it? Where is the trial court record?
My lordship, for your lordship, I am not, it is a transferred brief. I am not the lawyer for the trial court brief.
So that's what your party has taken any such.
Yes, my lord.
What is that? I want the trial court record.
I'll make it available.
Trial court record, look at his objections.
Objections, yes.
Objection. This lordship was objections.
I see.
Please, can I read, my lord?
That particular, where you have taken the objection that it is not maintainable.
Yes.
Paragraph number? Nowhere it is taken.
The para 3, my lord,
Yes.
the maintainability of a petition.
Maintainability of the petition in the light of that earlier compromise, not on this point.
No, what happened? My lord, 2 minutes. my
I've
lord.
seen the entire order, entire. PDF.
I'll read.
It's
I have
not there.
Yes, your lordship has seen it.
It's not there.
And,
Look at it, you look at it, if it is there, point out.
cause of, my lord, 21 of my objection statement before the trial court, the family court, the above proceedings are against the rule of law of land. In other words, according to the Article 20, subsection 2 of the Indian Constitution, a person cannot prosecute the punishment of the same offense of the other. Likewise, even according to the Section 300 of CRPC, a person once convicted, acquitted, not tried the same offense. It is not out of place to state that the above proceedings are governed by the Code of Criminal Procedure. Since the respondent has already left the prosecution of domestic violence and stated above, the right of the claim of a maintenance was subject the matter, he cannot prosecute again for the same claim under this petition is allowed. The same would be amount to violation of the Indian Constitution and also Code of Criminal Procedure. And as such, the petition need to be dismissed alone. The respondent is the husband. It is, well, they have said it. The Code of Criminal Procedure is not maintainable, and it remains that 120 proceeding. Now, very simple is the technical at my lordship. Technically, what happened, the word it may not have done, but it is overall.
I'll take that submission on record. Yes, next.
Yes, ma'am.
What is the other objection?
Others, my lord, once she has given up her rights, she cannot claim.
It's over. That is your submission number 1 is over.
Yes.
What is the other submission? Submission 1 with regard to already a memorandum of understanding in DVC case.
It is. The matter ceased.
And the children are not made parties, number 2.
Yes.
What is the third submission?
If the third submission, they cannot, 125 proceeding does not, because she has given a right, she cannot agitate the matter under 120, because she's well off and she's capable of maintaining upset. She's a postgraduate and she owns the properties and also. And what has happened? And still today, I have not seen the children after the 8 years till today. And for whether they got degreed or studied and all this, I was not known. It was not informed. And she cannot use as an ATM for me. I lost my job. I resigned. Running around back to Bangalore and all, I lost my job. I don't have a independent income. In spite of that, I pay 5,000 rupees as terms of the order of the maintenance to her. She receiving it. So therefore, my lord, the 125 proceeding led by the trial court is unsustainable under law. It is not maintainable because the child, there is erroneous in the orders, and it has not been. He has also said that in the GWSB, your all could see, my lord, the issues framed and the exhibit
Those
1
are
to
all
5.
not relevant for this application.
Yes.
Please make submissions which are relevant for this application. What
No.
else is your submission?
My humble submission to your lordship is that in a DV Act, she has given up other rights, disputes rights, and settled once and for all. And she cannot re-agitate the matter under any other law.
Yes.
That is my submission.
Yes, what is your submission?
My lord, this.
Citation.
Order of maintenance of wives, children, parents, protection of women from domestic violence act, so on and so.
For that proposition, no judgment is required. Apart from that, what you want to say on the facts of it?
Apart from that, my lord, even after, during the
What
pendency.
about that house as per the settlement that is given to you?
House,
What are you doing with that? What is the income you're deriving out of it?
my lord, because of the debts I borne for this education, I sold the property for 33 lakhs. The expenses, in the children expenses itself is more than 30 lakhs. That's why I sold that property for 33 lakhs. I was not in the position to bear the expenses.
Please come. Agreed with the orders passed in criminal miscellaneous number 480 of 2014, dated 17 November 2017, whereby the court had granted an amount of rupees 15,000 per month to the wife towards her maintenance from the date of petition till her lifetime, as well 7,500 each to both the children. Further, an amount of rupees 1 lakh towards the educational expenses of the daughters, commencing from the next academic year 2018-19 till completion of their education. Further, and litigation expenses of 25,000, one-time mitigation expenses. The husband is before this court. Then counsel appearing for the husband submits that earlier the wife had filed criminal miscellaneous in the DVC Act the Domestic Violence Act, that is DV Criminal Miscellaneous number 19 of 2011. In that, a settlement was arrived in between the parties on 19/4/2011. As per the same, he has agreed to deposit a sum of rupees 15,000 towards the welfare of his minor children. And he has also, that he is paying 15,000?
5,000 every month they pay.
15,000, not from this DVC.
Yes.
As per the agreement
Yes,
is paying.
yes, my lord.
And also, he owns a flat apartment in Bangalore. He gifted the same to the children, to his minor daughters. In view of the said settlement, as the disputes between the parties have attained finality, the wife cannot file an application under 125 CRPC, and the same is barred by res judicata. This aspect was not considered by the court. Learned counsel further submits that when the wife is seeking maintenance to the children also, the children should have been parties to the petition, and they were not made parties, and mother is the only party to the proceedings. In such case, she cannot seek maintenance to the children, and this aspect was also not considered by the court. It is further submitted that the father has not seen the children, and he is only made to pay the money, but he is not. The wife has not given any visitation to the father. It is submitted that all these aspects were not considered by the court. As such, the petition needs to be allowed. Anything else? Land counsel appearing for the respondent does not deny the fact that an amount of rupees 15,000 per month was the husband is paying as per the order passed by the court in the DVC proceedings. And also he does not dispute the fact, as per the agreement, the flat is transferred in the name of the wife. It is in the name of the children. It is a submission that the said flat is sold on 9/11/2023, as the wife is not in a position to bear the educational expenses of the children. She has to sell the house and pay the amounts towards the educational expenses of the twin daughters. It is submitted that the wife is not in a position to take care of herself, and it's a duty of the husband to maintain the wife and the children. As the amount that is paid, it is 15,000, was not sufficient. The court, they have come up with this application seeking maintenance. Then when you have sold the property, then this also will meet 1 lakh per month.
My lord, as far as educational expenses is concerned, as I sold the property.
2011 was a property. You sold it in 2023. That is after how many years? Almost 11 years you have sold the
12
property.
years.
So the amount you have derived is 30 lakhs.
Yes.
So now the court started from 18 to 19. You have sold in 2023.
23.
So that amount is sufficient for the educational expenses.
Educational expenses.
It is sufficient.
Yes.
So why should he pay 1 lakh now?
No, as I sold the property.
You sold the
My lord,
property.
he gave the property with the intention for their residential purpose.
You have been enjoying it till 2023. For what purpose he has given? You have sold it in 2023. So no, there is no point of educational expenses now, because it is met by with his property.
Yes.
Yes.
Yes, ma'am.
The wife? Before that. $15,000. Next para. In the same para, the court on the issue of res judicata had rightly dealt with the petition. When the relief that is sought is under the Domestic Violence Act, the act itself makes it very clear that any of the relief that are sought or in the domestic violence case that are granted or apart from or in addition to the other reliefs that a party is entitled. When under the said act, when when they have entered into a compromise, the submission of the council that under 125 they cannot make any application is has no legs to stand. The court had rightly held that it would not amount to res judicata. Then coming to 125 CRPC proceedings, the court has granted the 1 lakh educational expenses. As far as those educational expenses are concerned, already when he has given a flat for the children, they were enjoying it for till 2023. In the year 2023, they sold the property and they have paid the educational expenses. Now they have become major, and as such, the husband need not pay any educational expenses to the children. Then coming to the maintenance, the wife is the children are already their majors. The wife is already paid an amount of the court as per the settlement is already paying an amount of rupees 15,000. Hence, for the wife, another amount of 15,000 would serve the purpose, and in that they would be able to take care of the needs. In that view of the matter, the RPFC is partly allowed. The maintenance that is granted to the wife is affirmed, and the maintenance that is granted to the children and to both the educational expenses are set aside. Yes.
Till number 26, adjourned. 27. Till number 27.
Yes.
Hearing for the,
Yes.
hearing for the petitioner has been, my lord. My lord, we're challenging the order of the family court allowed interim maintenance to the respondent wife.
Page number?
Page number 45, my lord.
45.
Page number 31, my lord.
It's not page number 41.
31.
41 is your prayer.
Yes, 31. Annexure A, page 31, my lord.
Yes. Filed by the wife, so and so is partly allowed. The wife is entitled for interim maintenance of 20,000 per month till disposal of the case, litigation expenses. Open. What is your for the husband?
Yes, I'm for the petitioner husband, my lord.
What is the income of the husband?
My lord, let me just start with the respondent wife had filed an application for interim maintenance on the ground that she had lost her job due to COVID. Okay, the respondent wife, my lord, is an MBA graduate. She has acknowledged this in page 91.
Yes.
You may see, please.
Yes.
Yeah. And she had come before the court and stated that she had lost her job because of COVID. But the fact of the matter, my lord, is that she had voluntarily resigned from her job at that point. See, my lord.
Yes. Well, how much she was getting?
She was getting about 50,000. She was working with the Jana Bank and she was earning about.
Was it brought to the notice of the court?
Yes, my lord. This was brought to the notice of the court in our arguments, in our objections to the IA. And despite this order was passed.
What is your income?
My income is about 85,000, my lord. Affidavit of assets of both the petitioner and the respondent was submitted before court.
Please come to the order.
To the one?
Come to the order. Come to paragraph number 5.
Yes, my lord.
Yes.
$12 lakh per annum.
Read.
He is working as senior associate in Cognizant Technology Solutions in Bengaluru. As the said company does not disclose a salary. My lord, if you may please see the annexure.
We will read the order. After reading the order, we'll look at other papers. Please continue reading the order.
As the said company does not disclose the salary details to her without there being any order of the court, she is unable to produce the salary slip or any other salary proof of the petitioner. My lord, may kindly see the annexure F,
Counsel,
page 1.
the procedure in this court is you have to read the order. I should understand. Then you can take me to other papers.
Okay, yes.
Please complete.
He has further stated that petitioner owns immovable property and kept its details secretly. He has no other liability and all his family members have their own independent sources of income. He has intentionally and deliberately refused and neglected to maintain her. Further, she also requires 1 lakh towards the necessary expenses of this proceedings. Accordingly, she has prayed to allow IA number 4. The petitioner opponent has appeared before court through this learned counsel and filed his objections to IA number 4, wherein he has denied the case of the respondent wife by paragraph wise, except the fact of his marriage, and his case is that it was the applicant who forced him to leave the matrimonial home on 15/9/2019 due to her aggressive and violent acts as she was verbally and physically abusing him. Though the landlord came and tried to pacify the respondent, she did not stop. On 17/9/2019, he filed an NCR before the Commissioner of Police and thereafter he did not return to the matrimonial home. As per the advice of the police, he resided in the matrimonial home between 15/9/2019 to 20/11/2019 and he continued to pay rent towards the said home for over 3 months. He never forced the petitioner to leave the matrimonial home and to keep her belongings in her brother's house. When he visited the house on 2012/2019, he found that the respondent had taken all her belongings and vacated the matrimonial home, and she did not answer the phone call of the landlord to inform him whether she would come back and reside in the matrimonial home, and accordingly he terminated the rental agreement on 2012/2019, and through email he informed the said fact to the petitioner. She replied his email after 9 days of vacating the house. It is the respondent who moved out of the matrimonial home on her own will and volition without any reasonable cause. It is further stated that the petitioner is an independent woman working with Jana Bank and earning over 40,000 per annum and is well capable of financially supporting herself. Her father is a reputed advocate in Chapra of Bihar and earns more than 20 lakhs per annum. Her family is affluent. The contention of the petitioner that due to COVID she lost a job is absolutely false. Though he is employed at Cognizant, his income is not 12 lakhs per annum. As contended by the petitioner, he is earning about 80,000 per annum per month. He, being the only son to their parents, has to look after his aged mother who is suffering from age-related ailments and has to repay the loan taken by his late father for his treatment. He is not in a position to pay the maintenance or the litigation
Yes, I have
expenses.
seen the order. Now, according to you, she has voluntarily resigned the job, number 1.
Yes, my lord. She has. You may please see annexure H, page 114.
What they say is in all these companies, when they want you to resign, they will make you to will make you to write such a letter.
No,
That's
my
what
lord.
is the
They will
process.
tell you that you're relieving and they will give you a certificate of conduct, but they will not say they're accepting your resignation. So it is very clear here that she has resigned
That is one
voluntarily.
aspect. Next.
Next aspect, my lord, she has voluntarily resigned because after resigning, she has filed for maintenance, interim maintenance.
No, she will resign the job where she's getting 40,000 and she will take 20,000 from you.
No, she had applied for 40,000 maintenance.
She applied, but the court has given 20. For getting maintenance, anybody will resign the job.
But my lord, the fact
And
is
we
she
can
is
understand, you're earning some 2 lakh rupees.
not 2
And
lakhs,
for-
my lord.
You're not earning, I'm saying if you're earning 2 lakh, court would give at least 40,000. So with that intention, she has resigned the job. Your salary itself is 80,000. Court would not give 40,000. Though she asked, she knows that it won't be
But there is
given.
a ruling by the apex court where a woman is able to support herself by working. She should support herself and work. She cannot rely on the maintenance
Yes,
of the
that is
husband.
one. That is
Yes,
one.
yes, my lord.
Yes.
And she filed for this interim maintenance in 2020, but in 2021 itself, she got another job. But she did not bring that on record of the court. So when she appeared before the family court on 2nd March 2022, she did not bring to the notice of the court that she is
When
already
she
employed.
resigned, when she resigned, date of resignation,
She resigned in
date
2020, September 2020.
September 2020. When is the petition filed?
19 June 2020.
19th June 2020.
19 June 2020, she resigned. And 24th September 2020, she filed the application.
24th September, she filed the application.
Yes.
Mm.
Now,
Now,
in
when did she got the job again?
December 2021.
When is this order passed?
Annexure K, this was passed in 2022, my lord.
5/6/2022.
Yes.
Is the order.
Yes. My lord, may kindly see Annexure K, page 134.
130?
134.
Hmm.
This is a Form 26 AS, ma'am.
Hmm.
She has not submitted this before the family court when it came up for hearing. And this was concealed by her, intentionally concealed, that she had already got a job. And she was earning a fabulous salary of 31,000, 51,000, 46. This is just the basic salary, my lord. Page 134.
What do you say?
This was concealed completely, my lord.
My lord, when the matter was posted for orders on IA, she secured a temporary job. It was not permanent. The matter,
Any permanent job for nowadays? Where is a permanent job?
there is no permanent
No
job.
permanency for the job.
She secured a job and she was working there. Thereafter, this order was passed. And therefore, I did not insist for payment of any money to me.
So let's take it like this. So from 24th September 2020 is the application. 19th June you have, so September, then again December you got job.
Yes.
24th September is the order. December 2021 she got the job.
That date may not be correct. I will just
So let
ascertain.
counsel for the respondent by way of not the counsel, the respondent shall file an affidavit before this court.
Yes.
When she lost the job.
Yeah.
When he joined in the job.
My lord, the resignation
and
letter
what
is right here on record.
Please wait. And right now, what she is doing and what was the salary she was receiving. An affidavit shall be filed before this court by 11th of August. This is marked on 11th.
13th of next month.
13th of August. Is 13th of August. Yes, next.
Cell number 28.
For
Rohini.
the respondent in this matter, my
For
lord.
the petitioner.
The original
my lords,
petition.
The order that against which I filed this petition, my lords, is at page 127.
127,
my lords. This is order on IA 5. The application was filed by me, petitioner wife, seeking to summon certain documents. My lords, here my petition is filed on the grounds that he was having an affair with another woman who is respondent to. And there were many travels, hotel bookings, etc. that were done, which I didn't have the original. So my application, my lords may just see my application.
What is MC for?
Is for divorce. Is for divorce. Now my ground for divorce is that he was having an affair with another lady who was also made party. In fact, adultery was also one
Please
of
come
the...
to your application.
Yes. Now
Where
my
is the application?
IA is at page 108.
108.
In fact, I just wanted to show when the IA was filed. IA was not filed belatedly. Now, my
No,
lords,
it's not about belatedly. What is the purpose of the application?
Yes, I'll just show my lords. My lords, IA is filed. The documents I'm seeking to summon, for example, the first document are, my lords may just see the table, the second para, booking for Mr. Mike Prince or Michael Prince with Ms. Komal Agarwal.
Please come to the affidavit portion. We'll see the affidavit and then go there.
Yes,
Affidavit is
just for a
filed.
pause, my lords. The application, the documents that I needed are hotel bookings and travel bookings where both of them have traveled together. Now, my lords, my affidavit, may I show at para 4 onwards of my affidavit? May I read from para 4? Page 112.
He says that there is no marriage at all. That's his case.
No. In fact, the no marriage, he does not say that with great respect. In fact, that issue was challenged before this Honorable High Court. He stated that jurisdiction is not there before the family court in Bangalore. According to him, the marriage was as per civil marriage in the UK. According to me, we had a civil marriage in the UK. We also had a marriage in India.
That lady is made part of this.
Yes.
Respondent she is?
Yes, she is a respondent. Because, my lords, and then that, when the jurisdiction issue, the family court held in my favor, he challenged it before this honorable court. This honorable court dismissed his petition saying that jurisdiction is there and y'all were married as per Hindu Arya Samaj and y'all are domiciled and living here. Family court has jurisdiction.
That's the case of the wife. That's where it
Yes.
can be looked into.
Then, yes.
Now, his case is that there is no marriage at all.
Anyway, that is rejected. That case of his that there is, he's not denying the marriage. Even in his objections, he's not denying the marriage. He only disputed the jurisdiction, which was set aside. The jurisdiction question, he failed to prove it. Therefore, and in fact, in the jurisdiction issue, this honorable court said, hear it expeditiously. So the matter was being taken up on an expeditious manner. Now, my lords, in my affidavit at page 112.
I'll have this on Tuesday. Tuesday. Yes, Tuesday. This is smart on Tuesday.
29, Rajendra Kumar Sungai.
Wife's petition challenging order on IA4.
Also, we'll have it on Tuesday. Yes, 30.
Channel number 30.
2:30 minutes on Tuesday.
Tuesday.
Regular.
Today, yes, Tuesday. It will come.
Very
Yes.
good. I'm great.
30.
30.
Intermodal in the extended.
Intermodal earlier granted is extended.
For the
Yes.
petitioner, my lord.
Wednesday. Then 31.
Interim order may be extended.
31. Appeal for responding. My lord, serial number 28.
It is for interim order to be extended.
All that, wherever interim order is there, it will be extended. Yes, 31.
Please, my lord, a pro bono matter for the husband. In the husband's petition challenging the order of the family court, granting interim maintenance. And he is with zero means except he survives on.
Can it wait till Tuesday?
I'm surviving on the old age pension granted by the government monthly.
So Tuesday will take it up. Tuesday. Tuesday will take up. Tuesday.
Uh,
Whenever it is convenient to you.
May I request you also to have it on Friday,
Friday. Yes.
on
next.
1st of August.
Yes.
Deeply
Yes,
allowable.
30. Yes.
32.
That's an interim order granted.
Interim order earlier granted is extended. Yes, 32.
32. Narasimha.
This on Monday. Yes, next.
Channel number 30.
There is some difficulty to the court, understand?
Yes.
Difficulty to the court.
Just one submission, madam. The petitioner is suffering from kidney disease and heart disease.
Mr. Counsel, when I'm saying difficulty to the court, again you state everything. Monday,
33. Anjan Kumar.
look at it wherever interim orders are there, extend.
33. Anjan Kumar.
Mangalore.
33.
33.
This on Thursday. Yes,
Please, ma'am.
Channel number 34.
Thursday.
Female children.
Channel number 35. Urgent.
Thursday.
Thursday, ma'am.
Yeah.
35 urgent. Channel number 36. Final hearing 36.
Thursday.
Channel number 37.
This also Thursday.
Number 38.
On Tuesday, my lord,
Tuesday, which one?
37.
37 on Tuesday.
Much.
Channel number 38.
Thursday.
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 38.
Ma'am, matter moved at end.
I'm appearing to the petitioner, 38.
File is there, just one moment, my lord. My excuse. My apologies, my lord.
Where is the impugned order?
My lords can find the impugned order.
The father is also entitled to celebrate birthday of the child as per schedule. Peruse the time mentioned in the memo. Now it is just necessary to provide opportunity to the father to celebrate the birthday from 11 a.m. to. When is the birthday of the child?
38. No, it's mood matter. My lord, 38.
Which matter you are?
38, my lord.
It is Mahmood matters I am calling. 38 is over.
Lord,
Yes.
Matter moved.
What is any urgency in 38?
please, my lords. It was posted day before yesterday as well. My lords, as a final chance gave, if I may. My lord,
38 on Monday.
Yes,
This is smart on Monday. Yes.
38 Monday.
great.
Lord, the order of the challenge is, my lord, the page 58, my lord, starts within the page, my lord, 57.
I've seen that.
Please, my lord, my
When
lord,
is the birthday of the child?
my lord, the birthday is on the 31st. My lord, according to him, my lord, star birthday is on 27th. My lord, that's what, my lord, my request is that, my lord, I'm relying on, my lord, only say that the child is a 3 years old.
Let the mother be along with the child.
That's all, my lord, they have a common place where they can visit, they can do it. They have no problem. My lord. That can, well,
Yes.
and time may be stipulated.
On this, the father is before this court. Agreed with
No,
the order.
mother is.
Mother is before
Mother
this
is before
court,
the court.
agreed with the order passed on memo dated 21/7/2025, whereby the father is permitted to celebrate the birthday of the boy from 11 a.m. to 8 p.m. on Sunday, 27/7/2025. Land counsel for the petitioner submits that the boy is 3 years old. And from how long the wife and husband are
3 years, 3 years.
immediately after the
No,
birth?
after the birth, 2 years.
Immediately after the birth of the child, they're staying separately. Considering that the boy has no acquaintance with the father and staying with the father from AS 10 o'clock, 11 o'clock to 8 p.m. It would be difficult for the boy. Considering the same, this court is passing the following order. The father can celebrate the birthday of the child from 11 a.m. between 11 a.m. and 8 p.m. And the mother is also permitted to accompany the child.
My request, they have to fix some time, 11 to 10 o'clock, 11 o'clock.
When you are saying that
Whole
alone,
night,
you can't-
he has to celebrate her home, right? After that, it'll take entire day, it'll go.
Not, you say that according to it is 31st.
No, they say, but now the star birthday.
No, star birthday, he's believing, not you.
No, but they do it in
But just now you
simultaneously.
said that
Please,
his father's.
please. My lord, I request, my lord, have it
No,
only.
no, let's not.
My lord, only one request.
Only on that note, otherwise in all these, the
Custody.
issues of children, I never grant
My lord, along
ex
with,
parte order.
my lord, here also one request, my lord, along with the mother, some common person along, because there's some allegations are there, they are forcing them sometime. It's some common person to be along with them, it's good, along with the mother.
No, that also creates another problem. Now again, you will come up with some, they
No,
come
no,
up
no,
with some
my lord,
allegations
we
again.
have no issue because there is allegation, when earlier time we have.
No, in the public place, what is the difficulty?
In a public place, my lord, oh, no problem. In public place, my lord. Please,
That is, the court has permitted him to celebrate at home.
please. No, he wanted to be celebrated at home, my lord.
Then let him do along with the respondent can,
Lord,
the
it's
mother can go along with the,
No, no,
along,
it's order says only public place it's up here.
then.
No, in
no,
public.
In the public place, no, then no, it's a third party is required.
Please, ma'am, please.
Yes. Signatures.
One pass over for
Please.
confirming the date of posting.
Yes.
I seek a hand delivery of this.
Hand delivery of the
What?
order.
The passover matter, serial number 15. At the 29, the date is given on September 28.
Where are they?
Passover, serial number 15.
Respondent.
Date.
Your Honor, we are offered 1 month, they are telling 15 month. I leave you with.
What is that you offered?
One month for accommodate the new house. They are saying 15 days.
That is better.
Please.
The father, it is
At
submitted,
least
this court has
20
interaction with
20
both
days,
the-
Your Honor.
This court has interaction with both the father, mother and the child. In the interest of the child, when the court has suggested that the father shall take a house for the child at the in the place where in the village or the place where he is residing.
Belur town.
They have come forward that both today it is submitted that the said proposal is acceptable to both the parties. Accordingly, the father shall provide an accommodation to the mother in the, what is that place?
Belur town, Hassan district.
In Belur town, Hassan district, where the Hassan district, number 1, number 2.
Within 20 days.
Huh?
20 days, Your Honor, please.
Within 20 days from today.
Please.
20 days from today. Whatever are the pending disputes between the parties, whatever the pending cases shall not be precipitated until further orders from.
I will
this
let the
court.
case number.
My lord, in CA crime number.
Write
now.
on paper and give it to them. So and so the matters shall not be precipitated. Next, the husband shall take care of the wife and list this matter on 21st of August, basing on how the things are transferred between the parties. Further orders will be passed.
Please.
Including all the trial court matters, GNWC also, including GNWC also, Your Honor.
All the matters I said, write that and give it.
Please.
Lords, kindly, Lord,
Yes.
can I make a mention, Lord? Lord, serial number 13, Lord, that party in person matter. Lord, what's happening, Lord? We want to go on with the merits. Lord, she has sought for.
You have given some 600 pages,
No,
something.
that was not now, Lord. It was last date of hearing, Lord.
when
What
you-
is happening here is not, here matters being adjourned.
Colleague was here.
Lord, we opposed, Lord. She said, I want to file objections to it. My difficulty is this, Lord. But the huge amount is not ordered. There, Lord, she is proceeding with execution. Here, Lord,
That execution is also stayed here.
no, Lord, it was stayed. Lord, thereafter, Lord, did not extend, Lord, the interim order, saying that, Lord, merely on that ground I will not extend. Then, Lord said, Lord, matter would be heard. Lord's heard the matter for some time. Then directed that both of us not have to file an affidavit. Both of us have filed an affidavit. At that juncture, my Lord, it was given to us across, even we gave it across.
No, some lookout circular is there in this.
That my
was
lords have
stayed.
already stated, my lord.
That's what I'm saying.
That is state, my lord. But execution proceedings, my lord, she's going on there. My lord, here I want to finish it, the argument, because according to me, on the face of it, order is
List
bad.
this matter, that whatever matter she has asked for adjournment, list it on Monday, inform it to her. That
I
way
have
we-
told her I'll mention.
No, she said some other matter is coming on
Tuesday.
Tuesday, she said.
Yes.
List this matter on Tuesday.
Kind leave, my lords. My lords, may I make one submission?
My lord, can I request for
Lords,
Monday
kindly.
itself? Monday also she's coming. There's a contempt, not that day also she's coming.
No, what her matter before this court is on Tuesday.
True, my
Another
lord.
matter.
Other matter, she's filed a contempt.
So many matters on Monday and Tuesday. I cannot accommodate also. Because I've given lot of dates from the last 2 days. Difficulty for the court, yes?
In list number 2 of serial number 4.1, when my name may be shown, my lords, because I have filed my NOC Wakalat on 17th June. Registry may be directed to delete the name of Sridhar Prabhu and my name may be shown.
Yes, yes. Any other matter?
My lord, one submission. My lord, one submission.
Yes.
Madam,
ಇದು ಮಂಡೆಗೆ ಲಿಸ್ಟ್ ಆನ್
Madam.
ಮಂಡೆ
madam, list two.
ಲಿಸ್ಟ್ ಎಲ್ಲ ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಸರ್
ಎಲ್ಲ madam.
ಮಾರ್ನಿಂಗ್ ಎಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು
ಮತ್ತೆ ಲಿಸ್ಟ್ ಓದ್ತಿದ್ದೆ ನಾವು ಲಿಸ್ಟ್ ಒನ್ ಆದ್ಮೇಲೆ ಬಂದಿದೀವಿ ಮೇಡಮ್. ಇಲ್ಲಾಂದ್ರೆ ಇದ್ದೇ ಲಿಸ್ಟ್ ಒನ್ ಅಂತ
ಸರ್
ಮಾಡ್ಬೋದು.
ಲಿಸ್ಟ್ 2 at the time of that submissions only it has been ordered ನೀವು ಎಲ್ಲ ಅದು ಮೇನ್ ನೋಡಿ ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆ ಬಂದ್ವಿ ಅಂತ ಯಾವ
ಹೌದು ಮೇಡಮ್, ಮತ್ತೆ ಲಿಸ್ಟ್ ಟೂ ಅಂತ ಹಾಕಿದರೆ ನಾವು ಲಿಸ್ಟ್ ಒನ್ ಆದ್ಮೇಲೆ ಬಂದಿದ್ದೀವಿ.
ಮೇಡಮ್, ಲಿಸ್ಟ್ ಎಲ್ಲ matters
common order has been passed yesterday also that the mediation drive matters common order is
ಯಾವತ್ತಿಗಿದೆ ಮೇಡಮ್?
ಮಾಡಲ್ಲ, ಎಲ್ಲ matter
ಮೇಡಮ್ ಯಾವತ್ತು?
ಮೇಡಮ್, ಮೇಡಮ್. ಮೇಡಮ್, ಮೇಡಮ್.
ಸರಿ
ಮೇಡಮ್, ಸೀರಿಯಲ್ ಇದು ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 43.
sir all matters in list 2 are referred to mediation Bangalore and that appearance date is given on 4/8 sir
ಹೌದಾ? ಓಕೆ ಮ್ಯಾಮ್.
that lok adalat branch ಅಲ್ಲಿ they will